Government's Board of Zoning Appeals meeting, its regularly scheduled meeting of June 16th, 2016. As we proceed with the docket today that's been prepared, I'll present the cases to the board for their review in today's public hearings. At this time, here at the outset, we would respectfully ask if you would turn off your phones or other electronic devices so they do not interrupt the board in its consideration of the cases. For today's public hearings, the board reviews the correspondence that's been submitted both in support of and opposition to each case. The board also reviews correspondence and recommendations from other government agencies in preparation for today's hearings and, in some cases, elected officials. In today's hearing, staff will present site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff's presentation, the appellant for each case will then have a chance to present his or her case to the board members. After the appellant's presentation, the board will hear from those wishing to speak in support of the appeal. If the appeal has opposition, the board will then hear from those parties. After the opposition presents its testimony, the appellant will then have a chance to return to the board and have a period for rebuttal. Under BZA rules, appellant has 10 minutes for presentation if there's no opposition present. In contested cases, however, BZA rules allow 15 minutes for each side to present testimony. We always note for those who are here to speak whether in support or opposition to a case, those 15 minutes are cumulative, so please divide up your time in advance so that nobody's left without the opportunity to speak in that 15-minute window. Should the appellant wish to provide rebuttal testimony after the opposition speaks, that appellant should reserve some portion of their originally allotted 15 minutes. At the conclusion of each hearing, the board will deliberate and then vote on the case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, specifically Section 17.40.180. All section numbers that we refer to today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The Zoning Code was adopted by the Metro Council and became effective on January the 1st, 1998. I'll introduce the entire Zoning Code and make it part of today's record for each case. The Metro Code requires a record of these proceedings. Because the BZA meetings are recorded for Metro Channel 3, it's imperative that anyone choosing to address the board come forward and take a seat here at the front and speak into the microphones. Any and all speakers should identify themselves by name and address and then make the desired presentation. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that on days like today, where only 4 members are present and the appeal fails to receive 4 affirmative votes, the appeal will be re-advertised for the next available public hearing. Applications that fail to receive 4 affirmative votes within a 30-day window from the date of the public hearing shall be deemed denied by operation of law, pursuant to board rules. Also pursuant to board rules, an aggrieved party may request a rehearing within 60 days of the public hearing of the subject case. Additionally, aggrieved property owners may appeal board decisions to the Chancery Court within the same 60-day period. After that time elapses, the board's decision becomes final and no further action can be taken. For the appellants, if your appeal is granted, you are required to obtain the permit for which you applied. A permit must be obtained within 2 years in order for a board approval to remain valid. After that time, you go back to square one and might have to come back to the board for any such variance, special exception, or other approvals from the board. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the Board of Zoning Appeals. Now, Mr. Chairman, I would submit that all the cases have been filed in the proper order, that all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled for each of the cases today. Mr. Chairman, as you may recall, case number 2016-056 was heard on June the 2nd of 2016 at our last board meeting. The vote on that case, as you will also recall, was 3-3. The board elected, of course it stayed open since there was no 4-vote passage requirement. The case stayed open for a 30-day window so that the 7th member would be able to review the case, review the file, and come and provide his vote at today's meeting. However, that one absent board member fell ill and was actually hospitalized last night. And while he is out at this hour, he's obviously unable to be here with us today.
Okay, so John Michael, review what the rule says about a 3-3 vote deadlock and when it's supposed to be heard.
ultimately, whether it's 3-3 or just any other scenario where there's an absence of 4 affirmative votes on a case, our board rules, Rule 9, case decisions, Part C is in cat, in the event that 5 or more members are present, which of course was the case on June the 2nd. Failure to receive 4 affirmative votes within 30 days of the public hearing, the case shall be deemed denied by operation of law. So in that 30-day window, the case is just denied. And of course, the 30-day window, as I don't think we mentioned before, does run before our next regularly scheduled board meeting of July the 7th. Mr. Chairman, I would also point to our board rules, Part 17, interpretation of the board rules, Part B. The board may, from time to time, make an exception in these rules for extraordinary cases, setting out the reasons therefor, should the board wish to contemplate that approach.
I think our member going to the hospital is an extraordinary case, and I do want the applicant to actually have some closure to this case. So that being said, and as long as I've been on the board, I've never seen anything like this. I would like to make a motion that we defer this one particular case to the next meeting so Mr. Harper can participate, and thus suspending our normal rules of the 30 days. Is there a second?
I'll second.
Okay. Motion's been made to defer it to our next meeting and properly seconded. Any more discussion? Okay. Seeing none, all those in favor signify by saying aye. Aye. Opposed? It passes 4-0. We will hear this. We will decide this at their next meeting and see if he wants to participate.
And again, that meeting is scheduled for July the 7th, 2016. So we'll take up case 2016-056 at the beginning of the meeting.
Okay, thank you.
Here in the preliminary portion of our meeting, we always seek to recognize elected officials who are with us. I know I saw Councilmember Mina Johnson present today. I think the council member had indicated that she wished to speak at the time her case is called.
Can we do our consent first?
If you wish.
Yes.
Very well. For members of the public and any viewing audience at home, we utilize a consent agenda at the Board of Zoning Appeals. One of our board members reviews the record for each of the cases that are coming today and identifies any cases where the appellants have met the criteria for their requested action. If the reviewing board member determines that testimony in the case would not alter the material facts, then that case is recommended to the board for approval. We will enter into the case record those cases that have been so recommended, and if anyone is here in the audience in opposition to one of those cases, please raise your hand and we'll remove the case from the proposed consent agenda and hear it in its regular order. Our chairman, Mr. Ewing, reviewed for a consent agenda and identified case number 2016-065 for the property at 5304 Charlotte Avenue. Remnant Moore, the appellant, and Ms. Linda Dolwyn Smith West, owner of the property at that location, requesting a variance for their business signage in the CS district. That was the only case that was originally identified by Mr. Ewing for the consent agenda.
Okay. Is there any opposition to that particular case? Okay. Seeing none, we had another last-minute potential part of the consent agenda.
Yes, I'd like to move that we add case 63 to the consent agenda, and that the front setback variance requested be site plan specific. Specifically, that plan is dated March 3rd, 2016, and shows a proposed setback line between two existing dwellings.
Okay, so you've moved that to the consent. You've made a motion to move it to the consent agenda. I agree. I will second. So I think that's appropriate. John Michael, is there anybody in opposition?
Is there anyone in opposition to case number 2016-063 for the property at 1304 Clifton Lane? Seeing none, Mr. Chairman.
Okay, so we have two cases for the consent agenda today, case 063 and case 065. Any further discussion? Seeing none, all those in favor of the consent agenda signify by saying aye. Aye. Opposed? Passes 4-0.
With that, we'll take the moment to recognize elected officials who are with us.
And the people that are here for the consent agenda, follow up with staff about your permits and things like that. You're, of course, free to stay for the other exciting hours of BZA. But if you have work to do or you're working on your project, you are excused. So thank you.
Also with us today, Councilmember Fabian Bedney. Councilman Bedney, would you like to address the board? Very well.
Former BZA member, Councilman Bedney, welcome back to the BZA. Thank you for being here, and we're happy to hear from you.
Thank you for letting me address the board. I'm proud to be in the same room with my prior peers, Mr. King and Mr. Ewing, and good to see Alma Sanford from the Southeast at the BZA. The reason I wanted to ask you if that's okay with the BZA, with the board, is to ask something that when I was at the BZA, I wish people had asked me, and that is we are discussing legislation about Airbnb, about short-term rentals at the council, and I wanted to see if you guys have any feedback for me as a council member on the. She's laughing.
Yes, so a little bit of the history of those who don't know that are watching on Nashville Metro Network. The Council Lady Berkeley Allen proposed a bill that was passed last year to regulate short-term rentals, including Airbnb. And the reason that we're involved is if you don't like what happened to the staff, that we are the group to appeal that decision that they make. And so we've heard about a dozen of these cases, I think, so far. And most of them, or a lot of them, are people that kind of came here that were totally oblivious that there were rules related to short-term rentals and had rented, and many, once they found out that there was a law, they stopped their rentals and then came to get a permit. As a very common case that we get, a lot of these folks are faced with a year of, if they are found in violation by the codes department, even a first-time offense, you are faced with a year prohibition of being allowed to do an Airbnb. So, you know, we are only able to say you can have your permit or you can't, and therefore you have to sit out a year. So I'll let my colleagues kind of share their views about that.
Go ahead.
Well, it does seem like an awfully long time to be penalized, and there's no remedy for that.
Well, Councilman, what we're faced with oftentimes is somebody who, let's say if some friend of theirs from Chicago or Atlanta calls them up and says, hey, there's this great thing called Airbnb. You could rent your house out and make some extra money. And they went online and they signed up and they did it. And then they hear about the law. And if they've already rented it, unbeknownst to the law, they're in violation, and then they're prohibited for an entire year of getting a permit. As you know, there's a permitting process. The other thing that is, I guess, problematic about this whole scenario, this is my personal opinion, but I kind of understand some of the reasons why. You're in violation of the law, not necessarily just for renting it out, but for posting it on one of these sites, even advertising it. And so that's when the law kicks in, that basically, let's say you posted it and you never even rented it, and one of your neighbors sees it and turns you in, you're also potentially going to be punished for a year, even if you didn't know, what the laws were at the time.
Okay, well, I appreciate you being from, oh, sorry.
I'd like to make a comment about this, too. We heard from one of the people who were here that the Airbnb, at least, has put a notice on their website about Nashville having this law. Before that happened, I think it's true that most people had no idea there was a law. I have another concern that I hope the council will address, and that is some areas, the lack of looking after what's happening. I'm hearing some horror stories about a bachelorette party next door to someone's home, and they may have an ill family member or a baby that cannot sleep. And I think that there are some very serious issues with this whole thing, and I hope the council will look at the whole picture.
I really appreciate you humoring me on this.
No. And the other issue that I have, too, is for those who live in the popular Airbnb districts near downtown, Hillsborough Village, 12 South, Germantown, Salemtown, those permits are long been taken up, the non-owner occupied permits. And so what I wonder, kind of as a Nashvilleian, either people that are new to town or just weren't rushing down here to get their permit when others were, that there's certain parts of the city that there will never be or not be hardly, years and years will go by without any additional permits coming up. There's not a lottery, there's not a scenario where I could even get one. So right now that cap is there and it's, been determined, it's full in some districts. And so there might be a way that you allow a few people, a few lucky people, Willy Wonka golden tickets a year, that they are able to rent their home out. Like I said, I'm sure that would be huge demand in some of those areas that I was talking about. But as the system is set up right now, unless you're already in the game, you're never going to be in the game, probably, or at least for a long time.
Well, my district is very rural, and we have a different issue. I mean, we have HOAs that, when I supported this legislation originally, it was because I knew that the HOA will be preemptive and people will still be able to do a short-term rental if their HOA permitted it. And I'm coming to find out that is not the case all the time. So I wanted to know if in the mechanics of how we go about doing this, if there is any improvements we can do. But the feedback that you're giving me is also good. I'm a strong believer in asking the people that are going to implement stuff how it works for them. So thank you for humoring me.
I have another suggestion. Everyone has to pay property taxes on these rental properties that they own. So I guess it's November, Metro sends out the statement to pay your property taxes by February. It seems maybe a good way to inform people of this legislation is to put a note with your property tax statement. That way the public can be more informed.
Yeah, I never read my property tax bill, but
I think a lot of people do.
Yes.
Yeah, well, Charlie Cardwell's office is right upstairs, and
Yeah.
I'm sure that's probably
I
not.
have another comment, too. We were informed that homeowners associations, and I live in a community that has one, that it has no effect, that the city code and the law that the Metro passed about short-term rentals overrides any rule that the homeowners association may have.
That's no.
Well, that's what
Yeah,
my understanding was.
I don't think that's necessarily so, but I would consult your homeowner association or your lawyer. But it clearly, a lot of homeowner associations are now rushing to kind of put legislation in about that. And the way that we normally deal with homeowner associations here on the Board of Zoning Appeals is to say that's a private civil matter between you and your homeowner association, whether you can do whatever you're trying to do or not.
Okay, well, that's a good point, because I guess I'll have to double check with our lawyers in the council. What I understood is that the HOA restriction overrules the ability for you to get a short-term rental. So I'll it has to be spelled out even more clear in the legislation, and this is an opportunity to do that. And this is why I wanted to ask for this feedback. Thank you.
But Councilman Bedney, we appreciate your leadership on this issue and many other things has made our city a better place to live for everyone. And we look forward to seeing you at any time here.
Thank you. If you think of anything else, just send me an email if you don't mind. Thank you. And the same goes true for people listening, watching on TV. Thank you very much.
Thank you.
Thank you. Good to see you.
Okay, John Michael.
Mr. Chairman, our first case that we'll present to the board today is case number 2016-041, previously deferred. This is the case involving Mr. Ronald Scott, the appellant and owner of the subject property at 1124 Davidson Road, shown here on the zoning map, an area zoned RS40 out in the West Mead area. The request is for a variance from side setback requirements as well as square footage limitations in that RS40 district in order to build a new detached garage. Site plan, or rather the plating of the area shown here, gives you an idea of the area, and then the plan drawn gives an idea of the structure of the proposed garage. The appellant, Mr. Scott, is present and can come forward and present his case, explain the particulars of the plan as drawn, And the board members will see from the photos here the properly issued signage, views of the property, and then across the street in the lower right-hand corner, and the views up and down Davidson from the same area. Mr. Scott has opposition in this case. He'll have 15 minutes to make his presentation. Mr. Scott, please feel free to take a seat actually at the table if you would, and use one of those microphones. Okay. And then if you wish to save any time for rebuttal, you'll need to do so, and just kind of govern that as you see fit. Mr. Scott.
This was going to be...
Press the button, please, and identify yourself in your address.
Sorry. Ron Scott.
Address to.
Thank you for hearing this case.
What's your address here?
1124 Davidson Road,
Okay.
Nashville, Tennessee. This was originally going to be 1,200 square foot is what I was asking for, and you were going to grant me 869, and you wanted to, the side setback on code is 15 foot, and because of all the opposition, without me even going into trying to, downplay or describe why that opposition wouldn't make any sense, such as water runoff and things like that. What I would like to do is meet a compromise and keep the side setback at 15 to appease my neighbors. So there would be no variance in setback. And the only variance I'm asking for is, instead of asking for 1,200 square foot, I would like to ask for 900 square foot. So I would really only be asking for 31 square foot of a variance. And I told my councilwoman about this before the meeting, and she addressed the opposition. And their point is, makes very good sense, is all the other neighbors wouldn't know that I'm changing it at this point. So I was wondering to give them chance to oppose the 31 square feet that I'm asking for, if I could send out a second letter that says, hey, I'm not asking for 15 foot, I'm asking for no setback variance, I'm just asking for an extra 31 square foot. And the only reason I'm asking for the 31 square foot is mainly for construction reasoning.
So I'm confused. Do you want us to hear this case today, or are you asking to be deferred so you could talk to your neighbors more?
Well, I'm at your discretion, pretty much. I really didn't know how to go about this because I'm changing it midstream. You already have the sign made that says what you're asking for. So the reason I'm changing it is to try to come to a compromise.
If I were to guess, just based on my years of being on the BZA, even if you're dropping the other one, there might be some other people that still object. But,
right.
Have you met with any of the opposition or talked to any of the opposition personally?
Other than the fact that one of them stormed over to my yard after she got her letter and was irate, that's about it. It's kind of hard to talk to her.
Just a little bit of advice for dealing with the BZA and dealing with neighbors. I mean, that may or may not be the case, but when you're trying to, get people to go along with your variance, and you understand what a variance is, the law says one thing, and you're asking for us to make an exception to that.
Right.
Using the words stormed over and appeased is not going to make these folks happy to go along with whatever you're saying.
Well, I was just trying to answer your question honestly.
I realize that, but communication is king here at the BZA, and
sure,
making good neighbors, and in a tone that really is welcoming and open to people's suggestions. Yes.
In order to change what he's asking for, he doesn't need to re-advertise or.
So can we hear from the council person, actually? This will not cut into your time.
Sure.
But I would like to hear from you about this case, and where do you think the two sides are?
Yes, I'm Mina Johnson, representing those neighbors. First time I met Mr. Scott, he came up to me and asked me for his support. I did not know what support he was looking for, so I asked for the detail. He was asking me to support a variance of the size, and which is rather large because code allows up to 869 square foot of garage space, and he want to enlarge to 1,200 square foot. So I do not think it was my discretion to support, so I made aware of that. And another one is variance, side setback variance. So that sometimes it has hardship or will play into variance. And either way, it's always a good idea to ask for neighbors' support and what they think about it. And sometimes variance, if neighbors are okay with it, maybe the codes write a certain way, and it will be easier for you to accept hardship. But however, in course of talking to other neighbors, I have discovered that's not the case, because Westmead, as you can see in that picture, we do have rather lovely neighborhood, and it has a nice neighborhood character. One size, nice house, and then garage is behind in a subsize to the main house. So by allowing larger size and by allowing variance without hardship seems to me kind of bit stretch. So
Councilman Johnson, he has dropped one of the things that he's asked for today, but is still kind of wants a larger building than the law allows. So do you think, I start off by asking, how far apart are the sides? And if we were to defer this, is there a way to kind of bring the sides together? Or let me ask before you answer that question, how many people are here today in opposition to this case? Raise your hand. Okay, right there. So what do you think about that? I mean, can we accomplish anything by deferring this case and getting at least some direct communication amongst the applicant and the people that live nearby?
I wish it would have been the case, but Mr. Chair, as you have stated, thus far, conversation is less than friendly. So I think the neighbors, what I hear is, did not have any meaningful conversation until today, or not even today, because I was just informed of this change literally a minute before this meeting. And if I were known Mr. Scott would have going into that direction, I could have been a bridge between those neighbors. So as of right now, those neighbors was here because this case was deferred, not only once, but twice. Right. So each time a neighbor tried to come here, and one time actually they're here because they didn't know the case was deferred. So they came here in the midday, and in some case had to arrange babysitter and so forth, because it's not easy for anybody to come here midday, 1 p.m. So they made all the arrangement and came here, and then found out the case was deferred. So next month, neighbor informed me of the deferral. So I asked the head of the administrator, will this case be deferred? Yet again, the case was deferred the day before the hearing. So that time I was able to inform the neighbor, you don't have to come because the case was deferred. And this is the third time. So I think, as you can see the pattern, we are kind of far and maybe no time to
No, and I
bridge.
appreciate that coming from you, Mr. King.
Question, was a notice sent out to the neighbors for a meeting? I mean, that's a requirement.
For
Yes,
special
Mr. King.
exceptions, it is.
Excuse me?
Yes.
Okay.
Yes. The 600 feet, yes. So I guess where we are right now, as you said, this is the third time that we have met on all this.
Yes.
You've obviously had a lot of conversation with these neighbors, and then I imagine people that couldn't be here today that have written us letters too as well. And what the BZA tries to do, because someone is asking us to do something that the law does not allow, and to have extenuating circumstances, as you pointed out, a hardship, that we want to hear from the neighbors. We especially also want to hear from the elected official because we feel that they are the closest to representing their district and that they have a impact on what this quasi-judicial board does. So we value that you are here again, and I'm going to, unless you have something else to add, we're going to go back and talk to the applicant. But it seems to me your opinion on this is what?
My opinion is because we do have code and charter, and it specified give the authority to the board. Is this a hardship or not? So I will leave the decision to board.
But I guess what I'm asking you personally as a council person, are you in favor of this variance or are you against this variance?
The way I see it, I do not see as a hardship. So, for example, let's see, every single person who comes to this front of this board want to have variance over the size. This is the size variance for the garage because garage size is right now, I don't remember exact, is 20%, John Michael? Yeah, but my recollection is 20% of the main house.
Right.
So that's the written code. So if board were to give variance to every single person comes to front of this board, the size will be sometimes 30%, sometimes 40%, sometimes 23%. So as a board, as a body, do you want to go to that direction? I do not think so. So for that stance, I'm not in favor of the variance.
Okay. Thank you for being here.
Thank you.
Okay. So we heard from the council person. This is the third time, as she pointed out. And so why do you really need the garage this size? What's your hardship?
Well, I don't necessarily need it. I don't want the garage 1,200. I was just trying to come to a compromise and make it a little bit bigger for this to be able to utilize the maximum space. But it's 50% of your living space of your home. It's not 25% in R40, first of all.
Is it 50%?
50 for 17 floor is 50% of the footprint of the house.
Okay, 50%. So you're obviously still asking for more. I guess what the whole hardship thing is, why do you need more space? You just said you kind of didn't, but you wouldn't be here if you
Well,
didn't
I
want
need more space because of the layout of trying to utilize 869 square foot versus 900 square foot. So in all honesty, I'm asking for it. Can I give you, a reason why I'm going to die if I don't get it? No. So It sounds to me like, there is not a, tree in the way or anything like that. Now, when I put on there trees, I originally was going to put it in the back right corner where there were trees. I didn't specify that, and that was one of the objections of one of the neighbors, is that there were no trees there. But that's what I didn't specify where I was going to put it, so it didn't make any sense. I was trying to save as much as my yard as possible. But asking for 31 square foot, I don't feel like is that big of a deal.
Okay.
So,
Now, Mr. King.
Possibly, here's the opposition, and we have from time to time deferred, not to the next meeting, but let them go back and talk.
Well, as Councilman Johnson said, this is the third time this has been in front of us.
Right.
And so
That's what I'm saying.
it was her strong opinion that we hear this case today.
this is the first time I've spoke.
Well, we realize that, but the case has been deferred at least once on your
And I
request.
fully agree with that. I'm saying perhaps we hear the case, let the opposition express their opinion, and then maybe they go talk and see if they work out a compromise, and then we'll still make a decision
Okay.
today. That's my only
Okay,
suggestion.
we've done that in the past. So the way the BZA works is you get to put on your case, we hear from the opposition, and then any time you have left in your testimony, you could come back and use for rebuttal. So you're free to speak another 12 minutes and 29 seconds, or you could save that amount for the rebuttal or just speak a little bit longer if you wish.
I'll put it to you this way. I don't have anything else to say. I'll leave it in the hands of you guys, the board, and the neighbors. If they want to allow me 31 square foot, great. If they don't, great. That's all. I don't have anything else to add.
Okay, thank you. We're going to hear from the opposition again. Opposition, will you please come forward and state your name and address for the record, and, of course, why you're opposed to the new request, which does not include the setback.
Hello, I'm Teresa Miller. I live at 1120 Davidson Road. I live next door to Mr. Scott, who lives at 1124 Davidson Road.
I'm Gail Jaggers. I live at 869 Belton Drive. My property backs up to Mr. Scott's.
I'm Nancy Tomlinson, and I live at 1128 Davidson Road, right next door to Mr. Scott.
How long have you all lived on your various properties? I'm curious.
I've been there it'll be 23 years in July.
40 years.
And the same, 40 years.
Okay. Continue, please.
Okay, this has all kind of taken us by surprise. As Councilman Johnson mentioned, we've made arrangements to be here, and at the very last minute, our neighbor has proposed a completely different thing. So I hope you'll be patient with me as I try to amend the statement. And I have packets that I've brought for you all to show different things. So I'm kind of
Before you really get started, as you know, you have 15 minutes
I know,
cumulative.
I know. Thank you. And I want to thank you for your service and the opportunity to speak with you today. I thank my neighbors for being here. We moved our home in 1993. We've been very happy in our neighborhood. It's a big yard neighborhood. The environment is peaceful, beautiful, and friendly to nature. I'm here as a steward of our property. My husband, our adult mentally disabled daughter, and I enjoy full use of the sanctuary of our backyard. It's the single largest asset we own. I would like to say we do not oppose Mr. Scott's plan to build a garage on his property. We simply ask for the plans to adhere to the guidelines specified by codes in terms of side setback and square footage. The first page, Mr. Scott says he has demonstrable hardships, which I think we've established there are no hardships, so I'm not going to dwell on that. We oppose the variance for several reasons. The side setback, obviously, he has set aside, and I had several good reasons why we should not do that. I appreciate that he's volunteered that. The resulting building would have been 2/3 the size of his primary residence, turned sideways and placed just 5 feet off of our property line, essentially creating problems for us. And so, as demonstrated in my response, Mr. Scott desires more room. He has more than 5,300 square foot of open space surrounding his paved area with no trees obstructing that area. All 4 of the neighbors surrounding Mr. Scott's backyard do believe this plan to be injurious to their properties and not in keeping with the integrity of the neighborhood. The Belton neighbor, Ms. Coffey, could not attend the meeting today, but communicated her opposition to the variances to you in writing prior to this hearing. You've also heard from other neighbors in opposition to the variances. The 3 neighbors to the immediate left and the 3 neighbors to the immediate right of Mr. Scott's property and directly across the street from him on Davidson are opposed to the variances, as well as 5 neighbors on Belton backing up to his property. We will have a loss of enjoyment and buffer. That was with the sides. There are concerns about Mr. Scott's proposed storage of his vintage automobile collection, questions of on-site restoration, and environmental concerns about chemicals, fumes, paint use, and noise as the first vehicle on the site is unpainted and not fully assembled. There are pictures in the packet that I brought with me. But mostly, I would say that I'm here today representing at least 12 or 13 neighbors who charged me to come here today to say that they don't want variances in our neighborhood at all. So when Ms. Johnson approached us just minutes before the meeting and said what Mr. Scott was suddenly proposing, I feel like we wouldn't be doing justice to the people who weren't here today, who feel very strongly that they don't want to establish a precedent of variance approval in our neighborhood. We want it left intact. So that's why I guess I'm here speaking. I was caught off guard. There have been no attempts to really have this conversation. There have actually been some things that were unnecessary that have happened that you don't need to hear about. So anyway, I guess I'm in opposition to the variances.
Our neighborhood was built
Please identify
about,
yourself for the
excuse me,
record. Please identify yourself for the record.
Gail Jaggers. My property backs up to Mr. Scott's. I've lived in the neighborhood for over 40 years. I was reared in West Nashville. I've lived out there my whole life. When our neighborhood was built, the codes say 1 resident per acre or a little over an acre. When it was built, those codes were valid and necessary to preserve the integrity, excuse me, of our neighborhood. People buy into our neighborhood hoping that Metro codes will honor those codes that increase the value of our property. We're not jammed up against each other. Just any kind of structure is not allowed to be built that destroys the beauty of our neighborhood. Once you allow one variance, I know I'm not telling you anything, then everyone's going to want a variance. And they're going to come to you and say, you know, you did it for Mrs. Scott, why can't you do it for me? And there goes our neighborhood, there goes the value of our property. And when our property values decrease, taxes decrease. I'm going to leave you with one thought. This little bit of history. I was a senior at Peabody Vanderbilt in 1965, and Dr. Bjork told us that in 20 years we were going to see the crime rate raise sky high. We were going to see murders increase. Spouses would murder each other. Parents would kill their children. And our mouths dropped open, and we said, how can you predict that? And he said, when you overcrowd the living conditions of rats, those are the results. It creates too much stress that people cannot live with. And I leave you with that thought today. I hope you will honor these codes that have been in existence for almost 60 years and help us keep the integrity of our neighborhood. And I appreciate you giving me the time to speak.
Okay, who's next?
Nancy Tomlinson, 1128 Davidson Road. I'm almost at a loss for words because of change by Mr. Scott. But we do want to keep the integrity of the neighborhood. We want it, it looks nice now, and we want to keep it that way. I'll have to say that lately a situation came up that did not bode too well in making the neighborhood look well, and that is Mr. Scott has a very old car that he apparently wants to restore, so he pulls it out in the backyard, and for over 8 hours it sits there and smokes, and the smoke of the oil is permeating the air. It doesn't look good and it doesn't smell good. I really don't think, well, that'll be up to you all to decide what you want to do for Mr. Scott.
Why do you object to him getting a larger garage?
Because it is going to, if he's doing restoration work, it's going to bring in chemicals, it's going to bring in smells, possibly cars on cinder blocks. It's not going to look all that great.
Okay. Do you all have anything else to add, or anyone else in the audience to add about why you're in opposition to this proposed larger garage?
No, we thank you for your time, though.
Okay, thank you. And we will hear from, do you all have any questions of the, okay, thank you. We'll hear from the applicant again. Mr. Scott, come forward. So I guess the first question I have is, are you into restoring cars?
I have a car that's in primer, and I put seafoam in it as a winterizer, and I am been running it to try to get some of the sea foam out of it.
Is it your personal car or you?
No, it's a car that only thing it needs is paint, but it's in primer. It doesn't.
Whose car is it?
My car.
Oh, it's your car.
Yeah, it's my car. But it is not a beater by any stretch. And I'm not in the car restoration business. I own a roofing company. And this garage is to house a Sea-Doo, a truck, that car that they're talking about that is an eyesore to them. And at this point, like I said, I mean, you know, I'm just trying to compromise and ask for the least I can to suffice my vehicles. But, you know, I'm sure their argument for today was based off of the 1,200 square foot. If I would have known an easier way to reduce the square footage and take away the 15 foot before today, I would have. The reason I asked for those extensions in my rights of asking for an extension was to better prepare for this and try to figure out a way to compromise and redesign the garage, because I did have an architect that designed the plans for the original garage. So I had to get with him multiple times to see if we could squeeze what I had into that small of a space. But at the end of the day, it is a garage. I think people are getting on tangents about things that have absolutely nothing to do with this. It's a garage, and I'm asking for 31 square feet. You would think that I'm trying to build a skyscraper back here. Second of all, it's a one-story garage, and everybody that's up here giving opposition has got storage facilities in their backyard. I don't feel like I need to mention the fact that the air above your house is yours, but the thing about it is me building a garage that's not even any taller than my house, it's actually not as tall as a ranch house that I live in, is not going to obstruct anybody's view. And if I'm obstructing a view, I'm obstructing a view of what? My backyard? I'm hurting their view of my backyard. So to me, this whole thing, you know, yeah, 1,200 is probably too big at this point. But you know, we're talking about a garage here.
You confused me a little bit. You said you have an architect doing your plan for you?
For the garage, for the original 1,200 square foot, yeah.
But you also said you couldn't figure out a way to make it any smaller?
No, I said I extended my meetings to meet with him to see if we could try to make it smaller and still fit everything I had in there. Because 872 was 869 was the allotted area, and that's a lot less than 1,200, obviously.
Certainly it is.
And, you know.
Still didn't answer my question.
Okay.
You have an architect, and you can't say to the architect, maximum I can build per code is this. Show me a plan that'll let me do what I need to do in that square footage.
Yeah, that is the 900 square foot plan, and that's the shrinkage of the plan. And I don't have another copy of that with me today, but it went from 1,200 to 900. But I didn't even really want to bring anything until we had this meeting. So.
I don't understand. Didn't want to bring anything.
I don't understand the question.
What do you mean you didn't want to bring anything to the meeting or what?
I didn't want to pay him to build something that was 900, that designed something that was 900 if it was going to get denied, and then have to turn around and have him design something that's 869.
Okay, I understand. I understand that.
Any other questions for the applicant? Do you have anything else to add?
Not really, no.
Okay, let's close the public hearing. Deliberation.
Well, as much as 31 square feet doesn't sound like a lot, there's still no hardship identified, so I couldn't really support the variance request.
Nor could I. Didn't see a hardship, and I think with a little astute planning ought to be able to accommodate what he wants. If he had a reason, had a plan, said, I need a minimum of this to do what I want to do, that might be a different ballgame, but I don't see that myself.
So those watching on the Metro Nashville Network, if you come in front of the Board of Zoning Appeals or the Planning Commission, and you have to get neighbors' input, you know, our laws say that we send out notices to neighbors 600 feet away. The red signs go up, so it's telling neighbors, hey, I'm trying to do something here. So you could either call the codes office, look online. What we try to do is balance the need of the zoning law and what's proposed. And the Councilman Johnson talked about hardships. And when we give variances, that there usually is some sort of hardship that is asked for. And under these circumstances, the applicant did not state a hardship and also did not have much communication with neighbors. I cannot stress enough to those who try to come in front of this board that it is extremely important that you communicate with your neighbors. And if you don't communicate with your neighbors, you should at least communicate with your council person, and they could communicate with your neighbors. We've heard from two council people today, Councilman Johnson, Councilman Bedney. We give council people lots of leeway to come here, to address this board, to tell us what's going on in their districts because they're elected officials. And I know both of these people had very vigorous campaigns and they got elected in their district. And so it is important that as an elected official that represents this district, that you give us feedback. It could be in person, and we appreciate you coming in person. It could also be by letter or email. And this is a case where there was practically zero communication with the council person or the neighbors, or it was just in this very meeting. And that usually does not get you in good stead with your council person or the people that live there and have lived there for a very, very long time. And so I say all this in a very long-winded way just to allow other people that are trying for certain things to come in front of this board, that there has to be communication. And if you're going to make a case to us, before you make the case to us, make it to your council person, make it to your neighbors. And you may not be able to convince them, but at least you tried. And the people that come in front of this board, and they have had very little communication with their neighbors or their council person, it makes it a whole lot harder, particularly when people come here in opposition or your council person is physically here taking time out of their day in opposition. So that's how I feel about it. Okay, is there a motion from anyone?
I will move that since I see no justification for the variance, no hardship, I move that we deny this request.
And I'll second that. Okay, motion's been made and properly seconded. Any more discussion, board members? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? It passes 4-0. Motion denied. I mean, I'm not motion denied. The appeal is denied. The motion carries. The appeal's denied. Okay.
Mr. Chairman, that will bring us to our second case to be presented to the board, case number 2016-054. The appellant's Mr. Ian Dakin, also the owner of the subject property, located at 923 South Douglas Avenue in the 17th Councilmanic District. Shown here on the zoning map, an R8 zoned property. The case is actually an Item A appeal, challenging the zoning administrator's decision to revoke an STRP permit based upon having operated before the STR permit was obtained by the property owner and STR operator. Aerial map shown here shows the neighborhood as you bend through the curve into that part of South Douglas. Site visit gives you the straight-on view of the subject property in the upper left-hand corner and the view straight across the street to the bottom. Views up and down the street, South Douglas, shown in these two photos. The appellant is represented by counsel. Mr. Horowitz represents Mr. Dakin and will present on behalf of the appellant today. There is opposition present, so we remind Mr. Horowitz you'll have 15 minutes to present your case. And of course, if you wish to reserve time for rebuttal, please do so out of this original 15 minutes.
Okay, Mr. Horowitz, before we get started, I want to ask John Michael, since we had a large discussion about short-term property rentals, what is an item A appeal and why is this here?
Okay. Of the 4 types of appeals that can come to the Board of Zoning Appeals, item A is the one that is a mechanism by which appellants can challenge the decision made by zoning staff or, to the letter of the code, the zoning administrator. If they disagree with the decision, the action or an inaction by the zoning staff or zoning administrator. In this instance, as we see with many short-term rental cases, and this is not just specific to case number 54 at all, but to short-term rental cases where a permit is denied and the appellant thinks it should not have been, or in the alternative, where a permit was issued and someone thinks it should not have been, the mechanism by which that decision can be appealed is through an item A appeal, a challenge to the zoning staff's decision here at the Board of Zoning Appeals.
Okay, so basically what happened was they had a short-term rental, and it was the decision of the zoning administrator to revoke the permit.
That's correct. There was a permit issued in this instance. However, based upon other documents and information, it was determined that the property had been utilized for short-term rentals prior to obtaining the legally required permit, and that was the basis for the revocation.
Based on the discussion that we had earlier related to how this piece of legislation was passed, this board, the Board of Zoning Appeals, has jurisdiction. Obviously, we have jurisdiction over whether our zoning administrator was right or wrong, and so that's why we're hearing this case.
That's correct. When 6.28.030, the section of the Metro Code that governs the regulation of it, or that regulates short-term rental properties, was passed, it was kind of placed on the zoning division of the Codes Department to issue the permits. So ultimately, the decisions with regard to those permits are technically zoning decisions or decisions of the zoning staff. That's how they come to the board.
Okay, thank you. Mr. Horowitz, proceed.
Good afternoon, Mr. Chairman, members of the board. Daniel Horowitz of the Nashville Bar on behalf of the applicant in this matter, Mr. Ian Dakin. Before I present this case, Madam Chairwoman, I did want to address one thing that you said in reference to Councilman Bedney earlier, that a one-year suspension and revocation is a very harsh penalty. I want to offer this case up as a specific example of how true that is. Mr. Dakin, my client, had his permit suspended approximately 3 months ago. He was hopeful that he could wait until he received a hearing before this board before having to put it up for sale. Unfortunately, he has not been able to make his mortgage payments. His house is now currently on the market and up for sale because of this revocation. He lives up in Michigan. This was a property that he purchased with his retirement savings, and unfortunately the financial hardship as a consequence of having his short-term rental permit revoked has been tremendous. So I'm not sure that ultimately any relief here will result in any relief for him. It is essentially too late at this point. But I did want to thank you for your sensitivity to this issue and make sure that this entire board recognizes financial hardship here is quite severe.
I think the whole board is sympathetic. Hopefully I'm not misportraying that, but also wanted to correct you. This is the chairman over here.
Yes.
As indicated in the written materials filed with this board on June 1st, Mr. Dakin's appeal today presents 3 separate issues for this board's review. First, Mr. Dakin raises a procedural claim that he has not been given legally adequate notice of the allegations against him, and thus that the department's decision here should not stand. Second, he seeks to appeal to this board's discretion to enforce a fair and just penalty in this matter. Because the record here demonstrates conclusively that Mr. Dakin himself has never committed or even attempted to commit any codes violation, he respectfully submits that penalizing him with a 1-year permit revocation is unfair and unwarranted. Third, Mr. Dakin raises a jurisdictional argument that at least under the present version of the STRP ordinance, the Codes Department does not have the authority to withdraw a permit that has already been granted, as occurred in this instance. Thus, Mr. Dakin submits that he should receive the $50 fine that is specifically contemplated by the STRP ordinance instead. With respect to Mr. Dakin's claim that he has not been given adequate notice of the allegations against him, I direct this board's attention to the Codes Department's March 25th revocation letter. I have copies if I may approach you and
You could. Thank you.
So I would like to walk through this with you. First, I did want to clarify one other procedural issue. The STRP ordinance requires 15 days written notice before a permit can be revoked. That did not happen in this instance. As a result, I approached the Codes Department. They agreed with me and temporarily reinstated Mr. Dakin's permit for a 15-day period and then put this revocation into effect. Nonetheless, the only notice of the charges that Mr. Dakin received in this matter is contained in this March 25th letter, which provides that information received by the Codes Department demonstrates prior short-term rentals of this property before a short-term permit was in effect. That is all the notice that I have and that Mr. Dakin has to go on, and it is not sufficient for Mr. Dakin to be able to mount a defense. The letter does not say what the information is. It does not say when the alleged short-term rentals took place. And it does not say why the Codes Department believes that the rentals at issue were short-term rather than long-term. Simply put, I have no idea sitting before you today how to meet the charges at issue in this case. And this letter does not give Mr. Dakin legally adequate notice of the claims against him. Based on the lack of adequate notice in this letter, I separately attempted to gain access to the underlying information at issue here by filing a public records request with respect to Mr. Dakin's revocation, which I transmitted to Codes on April 19th. That request is attached to your written materials as Exhibit E, and it broadly requests all records having to do with this case. I have that here. I don't know if you have this in front of you. I'm more than happy to give you my copy if you'd like to review it. Now, Tennessee law provides that responsive records must be provided within 7 business days. To date, however, some 2 months later, no such records have been turned over, and as a result, Mr. Dakin respectfully submits that this board must presume that no such records exist and that the charges against him are without merit. Second, moving to his substantive claim, Mr. Dakin submits that a 1-year revocation is unduly punitive. Significantly, the applicable Metro ordinance provides that a permit may be revoked in the case of a violation. It does not say shall be revoked, and it uses permissive language for a reason. In other words, this board is expected to exercise its own independent discretion when making decisions regarding punishment. In this case, as noted at the outset, there is no doubt that Mr. Dakin himself is not at fault for any violation at issue in this proceeding. He lives out of town, and he purchased the property at issue with his retirement savings. Thereafter, he hired a local property manager to manage it for him, and his property manager, not him, was the one who applied for an STRP permit on his behalf. The Codes Department has confirmed this. Unfortunately, however, Mr. Dakin's property manager allegedly rented out his property on a short-term basis before the permit was actually in effect, giving rise to this proceeding. Mr. Dakin's property manager has taken full responsibility for any errors made during the permitting process, and he has acknowledged that all such responsibility falls on him and him alone. His letter to this board is included in Mr. Dakin's written materials as Exhibit B. That letter reads as follows. I am writing in regards to the short-term rental for 923 South Douglas Avenue, Nashville, Tennessee, 37204. It is my understanding that the permit was revoked due to a misunderstanding at the time of the permit application. I'm writing this letter to state that I, in no way, meant to deceive or mislead the zoning department in regards to the property at 923 South Douglas. If there was something I submitted that led the department to misunderstand the nature of the property at the time of the application, I sincerely apologize. And it is signed Marshall Burridge of Urban Nashville. Based on this state of affairs, I submit that Mr. Dakin should not receive such a harshly punitive sanction for an accidental error committed by a third party. Unlike many property owners who come before this board, and I think there are several here on the docket today, Mr. Dakin went about this the right way by seeking to obtain an STRP permit and hiring a local property manager to comply with all local rules and regulations with which he was personally unfamiliar. Unfortunately, however, his property manager apparently screwed up. I respectfully submit that given this state of affairs, Mr. Dakin should not be so harshly punished for an accidental error committed by a third party, and that the $50 sanction that is specifically contemplated by the STRP ordinance would be much more appropriate. I'll defer to my written materials regarding Mr. Dakin's jurisdictional claim here, but I will happily address any of this board's questions or concerns before stepping back.
I'm reading this letter from Marshall Burridge that you read to us from Urban Nashville, and he says, "It is my understanding that the permit was revoked due to a misunderstanding at the time of the permit application. I'm writing this letter to state that in no way, that I in no way meant to deceive or mislead the zoning department in regards to the property at 923 South Douglas. If there's something I submitted that led to the department to misunderstanding the nature of the property at this time, I sincerely apologize." That's just not a lot of information. So what happened?
Well, this is, I have the same problem that you do. I don't know what the charges are here. It's my understanding that the claim from the codes department was that at the time of the permit application, the property had already been rented. When I asked Mr. Burridge if that was true, he didn't know the answer. We would love to be able to look up the records to see which rental we're talking about, but we have no idea. I don't have any notice here.
So help me through this process. Your client lives in Michigan, you said?
Yes, that's correct. He
So
purchased.
how did he end up buying a house in Nashville, Tennessee, and then thinking, hey, I'm going to do this Airbnb thing?
Sure.
With his retirement money, as you said.
Yes, sir. So it's provided in the written materials at length, but the gist of it is he is a soon-to-be retiree. With his retirement savings, he purchased this property that he planned to rent out until he could retire and move down here himself. But in the interim, he was going to cover his mortgage payments by renting it out. He hired a local management company to rent it for him. It's my understanding that they were doing long-term rentals, but apparently some short-term rentals before the STRP permit was actually granted.
Did he hire them to do short-term rentals or long-term rentals?
He didn't hire them for any specific purpose other than to rent the property and manage it for him until he could move down. But after he acquired the property, a short-term rental property permit was sought out. It was granted, and then several months thereafter, it was taken away.
So did Marshall not know about the Airbnb law, the short-term rental law?
I think I'm fairly confident he did. That's why he applied for a permit on Mr. Dakin's behalf. It's my understanding that the charge here is that at some point before the application was finalized, or maybe while it was pending, I don't know. At some point before the permit was actually granted, allegedly one or more short-term rentals took place.
Gotcha. Board members, other questions?
Well, I guess I'm still interested in how you think that we can only give a $50 fine, or how the codes can, not us. Well, I guess you seem to think that the Board of Zoning Appeals can change the fine or change the punishment.
So this board has the authority to review, as an item A appeal, the codes department's decision. I'm looking at the enforcement mechanism provided in the STRP ordinance itself, and it provides that, this is 6A, the penalty for operating a short-term rental property without a permit shall be a $50 fine. Each day of operation without a permit shall constitute a separate offense. Now,
What about the shell part about a year?
well, so that is in the event of an application, right? So if there is This is a revocation. It is slightly different. I don't doubt that it would be wise to have the same mechanism in effect, but this ordinance, at least in my view, my reading of it, does not do that.
Why isn't this person from urban Nashville here today?
I didn't summon him here today. I guess I would be happy to file some kind of, to defer this if you'd like to hear from him. I thought that this was fine.
Okay.
Well, there's a Part B to 6 that talks about the 1-year waiting period. If there's a finding that a short-term rental property has operated without a permit, which is the charge here. So I don't know that we have the power to change Part B.
So I would respectfully respond that this waiting period applies to future applicants. This was an applicant who had already had a permit granted, and there is no, this doesn't refer to revocations. It refers to future applications.
I think we need help.
Yeah, we have a
here from-
lawyer here, and let's interpret this and what he said.
My reading of the ordinance is that, I mean, it's very plain. Once, upon a finding that a short-term rental property has operated without a permit, there shall be a 1-year waiting period. So just reading the plain language of it, once the zoning administrator determines that a property has been rented without a permit, which this letter indicates, that Mr. Michael wrote, indicates that there was a finding of such, then there would be a waiting period from that day forward. I don't think it, based on the plain language of the statute, it doesn't differentiate between a revocation versus if you're applying now and haven't been granted that permit.
And Mr. Horowitz, let me remind you that you know how the drill works. You get to present, the other side gets rebuttal, and then you get, the other side presents opposition, and you get rebuttal whatever time you have left. Right now, it's 6 minutes and 17 seconds. Yes, there is.
I would like to ask before he goes away. Are you really asking, because you said the owner has put the house up for sale, are you asking for a reinstatement? I'm not quite clear on that.
I am. He's already paid me to represent him for the last several months. I think it would make very little sense just to throw it in. This hearing was already noticed. So yes, he would still obviously like it. I can't say whether or not financially it's going to ultimately impact him either way. I can tell you that this has been a tremendous financial hardship for him, and that he thinks, given the notice problems and given the fairness issues, the Codes Department's decision was incorrect here.
Thank you.
Any other questions?
Well, I think, don't we typically hear from the zoning department?
Since this is an item A, we can hear from John Michael. You can represent the zoning department in this.
On this particular case, there's a couple of key points. I want to follow on some of what Mr. Horowitz touched on. We've met with Mr. Horowitz more than once, and I'm quick to compliment before the board the professionalism with which he's handled the matter. He's been very good to deal with.
And the kind of the brief, the very detailed brief that he has submitted.
Sure, that's right. Very well lawyered, as one would hope once you retain counsel. I wanted to address first Mr. Horowitz's public record request, which he's correctly identified. He sent in to staff, he sent it to me specifically, or perhaps me and the zoning administrator, Mr. Herbert. And I am guilty of misunderstanding after a later meeting when we met with Mr. Horowitz and discussed the notice of revocation, 15-day requirement issue. I've obviously completely misunderstood and thought that he had what information he needed on that issue. Obviously, the information he has sought, he still seeks. So that's an issue that the board needs to be aware of. He has not received, I don't know what, I'm sure there are some probably emails or documents or something out there that he does not have, that he has requested. So I need to admit, I made a mistake, misunderstood him, and he is at large on a couple of documents, I'm sure.
Okay, so I think I asked this in one of our early cases that staff said someone was in violation of the short-term rental, and they said, we saw it listed on Airbnb before this date. And I said, well, where's the proof that you saw it, and where's the printed out? And they said, well, we didn't print it out or anything like that. What evidence do we have today that is it all in the packet, what we have about
Forgive me, I can't remember what all is in your packet. You'll hear from opposition today who have with them certain printouts and other screen grabs that are demonstrative of prior operation. I think some of that may be in your packet. However, our meetings and review of the documents that were shown to us in meetings with neighbors and other discussions with neighbors demonstrated to us that there had in fact been short-term rental operations at the subject property before the date on which the permit was issued. That was the basis by which the zoning staff and ultimately the zoning administrator saw fit to, and this is semantics, Mr. Chairman, once a permit is issued and it's determined, wait, that never should have been issued, very technically, it's probably more of a cancellation, which is codified in Title 16, I believe,
Kind of like
rather than a
an annulment.
revocation. But in following the language of Title 6, 28030, we went with revocation. Mr. Horowitz correctly identified the 15-day notice issue, and he's correctly also laid out the method by which we basically reinstituted the permit on that temporary basis, with the revocation taking effect after a 15-day window. With that, you know the basis by which the permit was revoked, that the 15-day notice issue was cured. You also have the acknowledgement that there are probably some public records that I've not even responded to because I thought he had what he needed and I was just wrong about that. I invite any questions the board may have about the particulars of either the property, the documents, or other information with regard to the ordinance.
I guess where we're kind of in a unusual or harder situation is, the owners in Michigan, the person from urban Nashville's here, and Mr. Horowitz is the lawyer representing the owner, the out-of-town lawyer. And so it's kind of hard for us to ask the question about, did you do this? Did you do this? Who did that? And normally when we have these cases, that it comes down to whether the zoning administrator was right or wrong. And this is one of these cases where I think his jurisdictional arguments aside, he's basically saying that the reason this happened was because of this person that they hired to rent the property. I don't know if it was short-term or long-term, and then they're not here, the owner's not here, and so it's harder. And then as far as documentation of what we really dinged him on, this is, you are in violation of the short-term rental law, but on this date, on this posting, you did this. So that's, I guess, my concern about all this.
I have a concern as well, and I'd like an answer for this case and future cases. Is it the standard operating procedure that when you send a letter with the 15 days notice, that you do or do not give information about what the person is being accused? That is the basis for your revocation or denial or whatever you're sending a letter about.
The answer to the question is information, yes. I think, and forgive me, I don't have the March 25th letter in front of me. We identify that the basis for the revocation here is prior operation without a permit. Now, lest I read too much into your question, in the sense of a formal charging instrument from criminal court where the burden of proof requires specific facts, dates, numbers, statistics, screen grabs, we don't send a bunch of documents in support with that. I will have to admit to you, Ms. Sanford, and to the board collectively, because this is a newer ordinance, a newer body of regulation, we haven't been down this road too many times. I think perhaps as evidenced by the fact that Mr. Horowitz said, hey, you didn't give us a 15-day notice first. We had to go back and correct that after the fact. So the mistake was mine on behalf of the zoning staff there as well. But fortunately, we were able to get that corrected without any undue burden, I suppose, on the process. So to your question, yes, we identify at least the basis is you operate without a permit. The basis is you've had this many complaints for these types of violations, whatever the case may be. But we just haven't been down that road too many times yet.
But you're just saying the basis is that you operate without a license and you're not giving evidence or any indication of any evidence about that?
No, I guess we're not sending documents in support of the letter.
Because as you know, our job now is, after this case, is to decide whether the zoning administrator was in error of his error in his ruling. And so if we don't necessarily know what the ruling was based on, that kind of makes it a little bit harder for us. So that's what we're saying.
And Mr. Chairman, you had asked a question about the representative from the property management company in, I think, kind of in support of Mr. Horowitz's explanation of that. He doesn't have subpoena power or anything to trigger that requirement to have that person here. I see what you're saying, that it would be very valuable to hear from that person. That's certainly someone who would have access to records to say, yes, it was rented. No, it was not rented before XYZ date. But Mr. Horwitz doesn't have the ability to drag the guy in here,
I could remember, I guess, a couple other cases similar that, you know, the property manager that did a similar thing came here and kind of fell on the sword, if you will, and said, well, it was my mistake and I just didn't file it in time. Mr. Horwitz, anything else?
If I just might make a couple of quick points. First, I want to return the compliment. Codes Department has been absolutely fabulous here, very easy to work with, and we understand that this is a fairly new ordinance and that there are bumps along the road of figuring out how to enforce this, and I didn't want to cast any aspersions on the Codes Department. It's been fantastic to work with them. With regard to Mr. Burridge, that is entirely my fault. I did not obviously try to subpoena him, but I also didn't tell him to come. I wouldn't know what to tell him, what to prepare. I have no idea what records to tell him to bring or what to do. So I didn't think to bring him here. That is my fault, and I don't want my client to be harmed as a result of that. I guess the third thing is my concern here is that it's the Codes Department that's supposed to be demonstrating the evidence for these violations, not Mr. Dakin or people who receive letters like this to have to guess as to what the violation is to come up with evidence to rebut a negative. I don't know what he could have done, other than read this letter which says information and doesn't provide any additional information.
Okay. Any other questions of Mr. Horwitz?
This is a toughie, isn't it?
It is.
So it sounds like maybe the company that your client hired to represent him may have liability if they messed up.
I think so. I'm not even sure that they messed up, though. I think it's possible that this was purely a misunderstanding.
Yeah, that's where I'm going, so we don't know.
Yeah, what Mr. Horwitz is saying is he was not notified exactly what violation on what day are you claiming. And we've had a case before where someone posted something on Airbnb. I'm not saying that this is what happened, but it was for 31 days plus, and the codes people then at the time just thought it was on Airbnb and they didn't look how long it was listed for. And so without kind of more information, this is a real hard case to kind of determine what really happened.
Maybe we should hear from the opposition if they do have this paperwork that was referenced.
Okay, we can hear from those in opposition, and Mr. Horwitz, you'll have about 5 minutes left.
Thank you.
In rebuttal. Those who are in opposition, please come forward and identify yourself and your address for the record.
Good afternoon, Commissioners. My name is Jason Bergeron. I am also a member of the Nashville Bar, but today I'm here as a neighbor, as a resident. My wife, Corinne, is here as well. We live at 925 South Douglas Avenue, and there are other neighborhood neighbors who actually live in the neighborhood here as well. I have a lot to address, and I'm going to do the best I can to leave some time for some other folks, and I have some responses. Hopefully we can allay all your concerns. This case is not nearly as innocent as being presented. With all due respect to counsel, I think that it's obviously difficult because the applicant isn't here, Mr. Dakin. Mr. Dakin has been seen in our neighborhood once when he moved in, said hello, and has not been seen again. So let me back up to around September of 2015 when Mr. Dakin moved into the home right next door to us. Our homes were built at the same time. They are the type that slightly adjoin and touch in the middle. We are 8 feet away from 923 South Douglas. It's my wife and I's first home, and it matters a great deal to us. We came into this process, and I'm a little embarrassed to admit it because I'm an attorney and I was a former Metro attorney for 4 years, that I was not really myself aware of the short-term rental ordinance. And we approached it, it was a property issue. We were trying to work with Mr. Dakin to have a dead tree removed from the yard. And initially there was one long-term resident who lived there for more than a short period of time. She was there for the month of September and maybe into a little bit of October, but nothing more. I would like to stress that there have not been any long-term residents after that time. We were trying to explore property standards and what happens when there's a dead tree, what responsibilities there are of a property owner. Within that process, it came to our attention, I believe this has been submitted to Mr. Michael for distribution to you already. If not, I already have copies. We became aware that the website Urban Nashville Vacation Rentals, which is operated by a group of local real estate agents, as early as October 1st, you may have, I don't know if you have this document with you, you would note at the top of the document, October 1st was listed for short-term rental. If you flip backwards to the back of that packet, you'll also see that there was a, if you clicked through, you could rent it short-term, and that was available at that time. It has indisputably been being operated as a short-term rental since October. That only ceased on Memorial Day weekend, I would note. So I would further submit, and we'll get to this, that this property was operated even after the permit was revoked as a short-term rental. So it was operated unabated for a very large period of time, and it only had a permit for a very short period of time in the middle. The statement that Mr. Horowitz made that it had a permit for several months is respectfully incorrect. And I would ask staff to confirm that. But moving forward, as we went through the process of trying to figure out what was happening in that time period, we contacted codes. And I believe you have an email chain between myself and Clint Harper, a member of Code staff, wherein he was presented with the listing for this short-term rental. And eventually I was able to get an acknowledgement from Mr. Harper on December 16th, 2015, that this property was flagged to not allow permits. In the event that they apply, it would be denied with their right to appeal to the Board of Zoning Appeals. That's Mr. Harper in a December 16th, 2015 email that I believe you all have as well. The first time we ever became aware from Mr. Dakin that he was operating the property on a short-term rental was he sent an email on November 25th, 2015 to us. He was already operating at that time, as the listing shows, since October. Mr. Dakin further admitted later in an email chain you have between Mr. Dakin and myself in early January. I would call your attention to January 12, 2016 email at 7:44 a.m. from Mr. Dakin. The third to last paragraph, I quote, "We have been working on the permit, but they ran out right as we bought the home. So we are working through options at this point." That's a really important admission from this applicant, who I think it's important to point out. Mr. Dakin's not here today. He's sent an attorney. He lives in Michigan. And as to the financial argument, financial hardship argument, I find that laughable, because I have spoken with Mr. Dakin on property standard issues, and on 2 occasions he had to cut me short because he was busy, because he was at his lake house in Michigan. So I find the financial hardship arguments insulting to this commission. And I find it very troubling that Mr. Dakin can forward those through counsel as opposed to appearing here before you today. But back to the email at issue, Mr. Dakin admitted that he had been operating without a permit. There were no permits available in this neighborhood in the fall of 2015. That's why they don't have a permit. But they ignored that. A local company who is in this business of operating short-term rentals, that's all Urban Nashville Vacation Rental does, operated this home for him without a permit. Mr. Dakin knew it. The company knew it. They couldn't get a permit. He knew the code, and he ignored it. And he said, they ran out of permits right as I bought the home, when he bought the home in September. So Mr. Dakin knew throughout the fall and into the beginning of the new year. Fast forward a few weeks later, I had been trying to obtain some progress from members of Code staff as to what was happening, because this property continued to operate as a short-term rental. My wife witnessed it. I witnessed it. We saw the comings and goings of cars and residents for 2 days at a time. And as it's continued, and we have additional photos available from throughout the spring of various cars parked in the in front of the home, if you all would like to see those. I made a codes complaint, a property standards complaint in mid-January. That was never resolved. It was noted at first that the inspector could not obtain access to the property, and then said that they don't have a permit, they're trying to obtain one. Somewhere in early February, they made an application because a short-term rental permit for non-owner occupied properties became available. They were granted that permit. We found out because a band had occupied that home and was holding recording sessions at 11 o'clock at night, loud recording sessions. And when we contacted codes, we were told, oh no, they have a permit now. And we said, how did that happen? How on earth did that happen? And in that process, I spoke to Marshall at Nashville Urban Vacation Rentals and said, I don't know how to understand how you got a permit, Marshall, and how you continue to operate. He said, well, yeah, we didn't have one, but we have one now. That was Marshall's response. So I think you have a raise credibility and accountability problem between Mr. Dakin and Urban Nashville Vacation Rentals. They point the fingers at each other, but they both, as has been demonstrated by Mr. Dakin's email, they both knew what was going on. So shortly thereafter, I think codes became aware of an honest oversight. Codes realized that they had known that the property had been operating callously without concern for the law for several months. And they utilized their legal right under the short-term rental code. I would respectfully disagree with Mr. Horowitz's legal interpretation of that code. I think Metro Legal has confirmed that. I think Metro Legal at the last zoning appeals hearing 2 weeks ago had discussed that issue as well, and the use of the 1 year penalty period when they found to be operating. And I think that revocation or that annulment, as Mr. Ewing said, was proper. This property indisputably has operated without a permit, knowingly by the owner, knowingly by the management company, as a short-term rental, non-owner occupied, without a permit. There were no permits available in this neighborhood for the large portion of this time. I think I've covered a lot of the other issues I wanted to raise in response to Mr. Horowitz. Again, I would really stress the timeline here. An application wasn't made until late January or early February, and I'll rely on codes to confirm that. They did not have a permit for a long period of time. That's just not correct. They knew what they were doing, and they ignored this code. This property owner who lives in Michigan and has not spent more than 1 or 2 nights in this home ever ignored the Metro Code, ignored his responsibilities. I would like to give some time for the other neighbors to be able to observe that as well, but I'm happy to answer your questions briefly. I hope I've been cogent enough. I'm a litigator, and I like to keep my arguments succinct, but obviously I'm very emotional about this. This is our home. We love our home. We love our neighborhood. We care about our neighbors. This individual is not a neighbor. He has not been good to this neighborhood. And he's been, and I would respectfully submit that the information that's been submitted on his behalf is incorrect and dishonest.
You've said a lot today, and I might not have picked it all up, but did you say you made some complaints to the codes department? Was it the zoning department, or was it the property standards department?
The property standards division, I'm sorry. We made an online complaint in early January because, respectfully, I hadn't gotten responses from Mr. Harper in following up to the emails I sent him in December after he said, it's been flagged on December 16th. I said, well, Mr. Harper, what happens now? They continue to operate. How do we get them to stop? As another avenue, I tried to make a complaint online, on the online codes complaint, and that was opened, and it held open, and then we couldn't get traction there. It was very frustrating, and I know codes is working hard, and this is a new thing to deal with. I've met with Bill Penn. I understand how difficult that is. Oh, and one other item, if I may quickly. Colby Sledge, our Metro Council member, is well aware of this issue. He has relayed his support that this appeal be denied, and he feels very strongly about it. I knew he couldn't be here.
Yes, we have the email from Councilman Sledge. You referenced a email that they said that the city ran out of permits and they didn't. Where was that email?
I have more copies for you if it's not in your packet. I thought I had submitted that, but I will.
I think some. Let's see.
It's right here.
I have additional copies, Mr. Ewing. Thank you.
The question for codes department. It's section R, denial or revocation of permit. Item number 1 is about filing of 3 or more complaints within a calendar year regarding the permit. Are those complaints just strictly about whether or not someone has a permit legally or is operating legally, are those, well, does the codes compartment consider other complaints like, trash in the yard or something that would, like the Property Standards Division would look into? Hopefully I'm
No,
not-
they don't just reply to, or correlate with the question of do you have a permit or not. They can go beyond that. The language, of course, which gives you regarding an STR permit, the operation of an STR might include noise complaints, trash complaints, parking complaints, whatever else. So I think that, and I'm speaking on behalf of the Property Standards Division, with whom I do not work immediately, but it's my understanding they've always treated that very broadly in the reading and application of this ordinance. In much the same way that when we go down to Section 6, forces some interpretation, how do we interpret the $50 fine? Of course, this board's never had legal authority to issue a fine. So we've always understood that portion of the ordinance based upon our conversations with the council sponsor of the original bill, Councilmember Allen, to be the environmental court cases if there is merely some violation of some aspect of 628 that doesn't give rise to revocation. Say, for example, Ms. Carpenter, if you had an STR at your residence and somehow there was a problem with parking in the grass on a repeated basis, that would be a case that would wind up in environmental court and might trigger a $50 fine for you. Subsection B under 6, of course, talking about operating without a permit, triggering the one-year waiting period for a permit, is, of course, handled here at the staff and then at the board level.
But if it ends up in environmental court, let's say for parking on the grass, the example you used, then if that offense happens several times, then does the codes department revoke the permit?
Section 2 of Section R, the very next one after what you read, gives the authority for precisely that. If the codes department determines violations of the section have occurred, the permit to operate an STRP may be revoked.
Okay, I didn't read far enough, thanks.
One additional matter, Mr. Chair, if I can make quickly, another item you have in your hands. There's a copy of some calendar items that I believe has been submitted to you.
Yes, from Urban.
To explain what that is a listing from the Urban Nashville Vacation Rental website that, and the yellow days indicate occupied dates that were not available to be rented. And as you can see at the bottom of the screen, that was taken April 4th. The vast majority of that time, I would submit, this property did not have a permit, and yet they continued to operate. As evidenced by, I can testify that I witnessed that, my wife witnessed that. And
So
other
the yellow
neighbors here.
dates are the ones that were booked?
Booked, yes. That was, if you went on the website and looked at what was booked, that's what
4
that
or
is.
5 days a week, pretty
Screenshot
healthy.
of, yes. And so I would submit that even after they had their permit revoked, they kept operating.
I saw that exhibit as well, but nowhere on that exhibit was identified what property it was, unless I'm missing.
Well, and all I can do is, it was a struggle to get proper screenshots. When you print out a copy of the page, those yellow things don't appear. It's kind of a live thing. All I can do to you as an attorney in this town and a member of the Nashville Bar is submit to you. I printed that off from the listing page for 923 South Douglas on the Urban Nashville Vacation Rental website on April 4th, which is indicated at the bottom, and those indicate dates that it was booked. And I would hope that the commission would accept that as it is. But I understand your concern, and that's my testimony.
As a lawyer, I do accept that because I know the punishments for you lying to a quasi-judicial board or.
I also am an attorney, and I appreciate your comment.
I would appreciate that.
So, why do you think this went on so long without action by, how did they keep on renting this property if they didn't have a permit?
I think that first let me say I appreciate that how hard Codes is working on this. I'm a former colleague of Mr. Michaels. I'm a former colleague of Mr. Herbert's. We all work together at Metro Legal. I understand how hard they are working to figure out how to deal with this ordinance, and my wife and I have become very invested in this now, in this issue. I'm very concerned about it. I've been talking with Colby Sledge about it. I saw Councilman Schulman sitting over there. We spoke at a neighborhood meeting a few weeks ago about what can be done, because I think there's a real problem with non-owner occupied permits, and there's a lot of callous behavior going on by speculators who are treating these like hotels. I thought we had done the right things. I thought by getting an acknowledgement from Codes in December that it had been flagged, that would be a start, and then maybe they would start to build a case to sort of do some sort of cease and desist, some sort of environmental court citation for operating without a permit. We were working really hard on that. We were trying to figure out the angle. We were having a hard time getting communication back. It was pretty frustrating. That's not all. I don't think that that's through any fault or intentional act of codes. I think they're trying to determine, as I appreciate Mr. Chairman discussing, at the beginning of each of these issues, as you did last meeting, how this is a new issue and people need to be educated on it and it's a problem. And I think staff may be figuring out how to respond to complaints like ours. And I know staff is very overwhelmed. I know how hard all of our Metro employees work. I was one. This is a tough thing to get our hands around. But I think that everything I presented to you today, respectfully disagreeing with the jurisdictional arguments Mr. Horowitz has presented, it's indisputable that on the issue before this commission, this property was operated without a permit. It was operated knowingly, and it was operated very disrespectfully. They knew what they were doing, and they ignored it.
Let's go back to this email that was sent on January 12, 2016, that you quoted from, where I guess Mr. Dakin says, I hope you saw that I did let you know we plan short-term rentals. This is to help with the cost of the home until we can work out our lives to be able to spend a good amount of time of the year in that home. We've been working on a permit, but they ran out right as we bought the home, so we were working through options at this point. If we are unable to do so, we most likely will have to sell the home.
Yes.
And there's a for sale sign in the yard right
That's
now.
actually a for sale sign in my yard. We're selling our home in part because of the frustration with this process. We're going to move to another neighborhood. But we feel so strongly for our neighbors.
So you're selling your home, but you still feel strongly
yes.
come here and.
Yes, I feel that strongly. And I came 2 weeks ago when it was deferred because of a notice issue, and I'm back today. My wife's back today. We feel very strongly about this. We care about our neighbors. This was our first home. We love our home. We loved living there.
If it weren't for this, would you probably stay?
This pushed it over the top. The constant frustration with this. We're gonna try something new and try a new neighborhood, but this was the last straw because it's gone on for this many months, and I think things really snapped the evening in late January, early February when a band was having a recording session in the home. The day before, they'd shown up on our front door and said, "Hey, I have this band here where we're going to be recording." The rental company said that's okay, and I said, "No, that's not okay." I said, "I'll tell you what, we'll be home at 6 o'clock from work every evening. You can do what you want before then." The next night, 11 o'clock at night, there was a full band in the living room of their home having a recording session. This has been a nightmare, and it's been deeply distressing. And with all respect to Mr. Horowitz, this applicant is not innocent. He knows what he's doing.
Just on another personal question, and I ask this for the larger community in Nashville, as you are looking for another home, hopefully in Davidson County, Nashville, Tennessee, are you going to look to see where Airbnb or short-term rentals are in that neighborhood and not live next to one?
Well, yeah, we've done that to try to avoid the where we are living. Is actually has a condominium association, and the association has a specific restriction on that. And so I was enjoying hearing the conversation at the beginning of this meeting about those restrictions. I feel very strongly about those private restrictions that are in the documents for our condominium because I plan to make sure those are enforced to make sure that this doesn't happen to us again. But I would submit, and I would hope the commissioners would discuss with council about this. Non-owner occupied properties are a major problem in this community. San Francisco and Denver have done away with the ability to do that at all. Because when you're an owner occupied, you have to face your neighbors some days a week. When you're a non-owner occupied, you can live in Michigan and not face anyone and just laugh all the way to the bank. And that's the real problem here. It's things being operated like hotels in neighborhoods, and it's a real problem. And either we need to strengthen the code to have real enforcement for these non-owner occupied properties, or we need to get rid of them altogether and only allow owner occupied properties to operate.
Okay, thank you. You said you wanted to hear some other neighbors to speak.
We have some other neighbors present who I think would just back up and testify, provide more proof that this has absolutely been operating.
Do you have any questions before he?
This doesn't have to do with your case, but did you say you're working with a council person trying to get changes, maybe?
We've talked to Colby Sledge, and I know Councilman Sledge has proposed that legislation to expand the penalty to 3 years, and I think that's a great idea. Councilman Schulman was great. He talked to me and said, "If you have ideas, come to me." And I've been doing a lot of research on this issue, and I hope we can have more conversations on it.
And Council Lady Berkeley Allen, who is the author of this original legislation, I think is definitely also working on it. You heard from Councilman Bedney that was here earlier that had some, wanted to hear some input. So yes, this is on the radar screen. So if anyone has any feelings about short-term rentals, one way or the other, let your council person know, because it looks like more legislation or different legislation might be coming. Thank you.
Let me ask you, do you
Yes, sir.
also see a problem with owner occupied?
I see less of a problem with that, honestly, because I think that this city's a good place, and our neighbors take care of each other. When you have to come back on Sunday afternoon after your weekend away, when you've rented your own home out to someone, and face your neighbors from Sunday night till Friday morning, things are a little different, and things are handled a little differently. There's a lot more accountability, and I think that the ideally the code could have a little more in the way of enforcement options for when a repeat offender permit is a problem. But I think it's very different when you have to face your neighbor getting in the car to work on Monday morning. There's somebody there that has to answer for that, and that's a big difference than when it's just some local company. And I have to say that it's been very disappointing to know that it's a local company, this Urban Nashville Vacation Rentals, in my opinion, who's a part of this, because they live here, and that troubles me, in my opinion, that the way I think they've operated, I'm troubled by that.
Okay, thank you. Let's hear from anyone else that wants to speak out in opposition to this. And please state your name and your address. And thank you for your patience.
Sure. My name is Carl Marsh. I live at 924A South Douglas Avenue, which is across the street. And thank you for, first of all, listening to my testimony. My wife and I, who's here with me, we've lived at this address for a year, and we moved into the address in July of last year. And it became obvious early on that this property was doing quite a bit of business as a rental property. And now that we've gotten to know the neighborhood better, we realized that it probably is the most active rental property, at least on South Douglas. We walk around the neighborhood a lot, and there have been numerous occasions in the last year that we've seen cars with out-of-state license plates in the driveway. We've seen people going in with suitcases, coming out with suitcases.
But excuse me, I mean, we're not disputing that they have, I guess you're testifying that you've seen people from out of state that are renting and coming and going. Mm-hmm. Why is that disruptive? And I guess how many times and what months did you see these rentals? Because we're trying to get a timeline too. So when has this house been rented?
We moved in July, and in August I can remember seeing people with suitcases, groups of people going in and out. And
is it every week?
Almost every week. I mean, it's been a very active rental
So
property.
when did it start in August? When did it stop?
I didn't notice any activity after, I'd say, about midway through May or 3 weeks.
But January, February, March, you saw activity
Yes.
at least a few times a month?
Yes.
How do you know there were rental people?
Well, I don't know that, but we'd see the maid come and clean up. We got to recognize her car. Mm-hmm. So, and this is kind of obvious to us because we park on the street in front, or my wife does, and so we're opening the front door quite a bit. And as soon as we open the front door, it's just obvious we see what's going on.
But you said you saw people with suitcases too.
Yes.
And out of town plates.
Yes.
So when did you, it's interesting, did you know about what this was and that Airbnb, that you could basically have this short-term rental in your house, or did you think that they were doing something that wasn't even legal?
I knew about Airbnbs, but I just didn't realize how common they were in our area. And so I really didn't think much about it at first.
Have you ever met Mr. Dakin?
No,
Never seen him?
no.
Any other questions? Anything else to add?
I think that's all.
Thank you for being here.
Thank you.
Anyone else in opposition? Okay, no? No? Okay. Mr. Horowitz.
Thank you,
You'll
Mr.
have
Chairman.
about 5 minutes.
I will try to make these points very quickly. First, there is no doubt that this property was rented, several months before, back in August. This is definitely rented. The question was how long it was rented. I think you've heard that there were rentals over 30 days. I just want to point out that short-term rental is a legal term, right? It's not understood as such by most members of the lay public as compared with someone like Mr. Berger in here, right? When I think of someone staying in my property for 45 days or 2 months, I think of that as a short-term rental. The law defines things differently. Secondly, with regard to out-of-town plates, of course they're out-of-town plates. These are out-of-town owners. His wife comes down with some regularity. There's going to be out-of-town people occupying this property, and they're going to bring suitcases. I don't think there's anything out of the ordinary there. Most importantly, though, and I guess without addressing the substance, there's clearly a tremendous amount of bitterness between Mr. Bergeron and Mr. Dakin here. I understand that started over a tree that Mr. Bergeron threatened to sue Mr. Dakin over several times and complained to codes about. The fact that the allegation that this is indisputable, I have a problem with. I would dispute it because I haven't seen any evidence to support what's happening here. I defer to your legal counsel's position on this, but this board does not take testimony on an item A appeal. This board does not hear new evidence on an item A appeal. It is reviewing the record below. I've asked for the record below. I've looked at the record below. It says information was provided. I don't know what that information is. I have no idea what was just handed to you in support of these allegations concerning short-term rentals. I can't confront this evidence. I can't explain this evidence. I don't know that this comports with anything resembling adequate notice and due process. That's a huge problem for me. And I did want to clarify one or maybe two final points. The allegation was not that this permit was granted months ago. It was that it was revoked months ago. And as I think you heard, they stopped after the revocation, and they did go on during the period between when it was revoked and thereafter because it was temporarily reinstated. So those are my concerns here. I have no idea how to confront these contentions that I have not seen. That I submit as a serious notice problem, and I don't. I understand that there are kinks in this process so far and that this is relatively new. I don't believe that Mr. Dakin should be punished and subjected to serious financial hardship. By the way, is very serious financial hardship. I'd ask that the testimony concerning his wealth and his lake house be stricken. I think it's totally inappropriate. I believe that he should not be punished while the Codes Department figures out how to maintain fair and legally adequate notice and enforcement of this relatively new ordinance. Thank you.
Mr. Horowitz, have you seen this January 12th email where your client basically says, I'm working on a permit, but they ran out as we bought the home?
It rings a bell. I'm not sure I've seen it definitively.
It's in our packet. I was wondering you probably.
I have not been given anything about it. I've seen whatever emails I was forwarded by my client.
So how do you respond to that in the sense that, it seems like your client knew that basically there's a procedure and that there were no short-term permits?
In two regards. First, I want to point out that short-term permits mean something different to you and me than it does for somebody else, right? He was absolutely renting his property out to people for months at a time, 1 month, 2 months, 3 months beforehand, and I think you've heard lots of people talk about that. I don't know what that specific email is referring to. I do know that as a consequence of those problems, they went ahead, or his property manager went ahead and got a permit. I don't know if we're talking about 3-day rentals during the period at issue here or not. What I do know is that Mr. Dakin was not responsible for them, and that there's been no evidence presented to me to suggest that the Codes Department's enforcement action was appropriate.
You just suggested that Mr. Dakin come to that property, maybe his vehicle, with out-of-state plates?
His
Am I
wife,
right?
sir.
What?
His wife.
His wife. Do you know how many times or when the last time they were here?
I believe they were here a month ago, he was not here. I believe his wife may have been here. The only reason I know that is because there was allegedly an incident with, between his wife and Mr. Bergeron.
Thank you.
Anything else to add for the board?
No, sir.
Okay. Any other questions, board members? Okay. Thank you.
Thank you.
We are going to close the public hearing. And at this point, let's start deliberation. And as you remember, this is an item A appeal. So it's up to us to decide whether the zoning administrator was at error in his ruling about revoking this permit. We've heard testimony from dueling lawyers who both, I think, put on a very strong case for their parties, very vigorous case. But at the end of the day, we have to decide, did the zoning administrator err? So I'll start off. It's interesting. Short-term rentals are the rage now, particularly with sites like Airbnb, and they are now heavily regulated by the city. And as we talked earlier, if you are in violation and operate without a permit, or you run afoul to the law, your permit is revoked, and then you have to wait an entire year before you can get another permit and rent short-term. So that's the law. We can't change that. That's the Metro Council. But that's what it is. We are the appellate version, if you will. If you have a short-term rental issue, you can come here and make your case as the parties have done today. This is an unusual case, as I mentioned earlier. We have a lawyer here, but we don't have the owner, and we don't have the person who from urban Nashville. So our job is to kind of decide the case based on what we heard and what's in our packet.
I don't think the administrator just arbitrarily picks out places to shut down. I just don't do that. I think they have evidence, testimony, and whatever. While it may not be presented to the appellant right now, I think those things are readily available.
Well, I think by virtue of us having this information in our board packet, initially I didn't understand the information until it was explained. It looks like the Codes Department did have information that would, I guess, justify revoking the permit.
Okay. Does anyone have a motion for us based on what you just said or what's soon to be said?
I will support the administration.
So your motion is to what? I guess put a little bit more in legal Robert's Rules of Order terms, either uphold the zoning administrator or overrule the zoning administrator. So which is it?
I'd move to uphold the zoning administrator.
And based on, you didn't think he made what? The zoning administrator did not make an error or anything like that?
I think that he has the data necessary to back up his substantial, lost of words here.
It's your motion. So start from scratch. So you are what?
Well, actually, the appeal is by the applicant right now is the owner, correct?
Yes, it's an item A appeal. So we either uphold the zoning administrator's ruling or overturn the zoning administrator's ruling. And the zoning administrator's ruling was to revoke the permit.
And I'm voting to uphold that. Yes, I'm looking for the right word.
Based on what? usually it's because you don't think he made any mistakes or errors.
Exactly.
Okay. So that is so repeat your motion then.
A motion is I move that we uphold the zoning administrator based on, I am confident that he has the data to back up and substantiate the revocation.
Okay. I would propose a friendly amendment to that, if that be that basically the zoning administrator did not err in his decision to revoke the permit. That's what I think your amendment should.
That's what I'm trying to say. Thank you.
Okay. There is that motion, and I guess since I made the friendly amendment, that is my second. So, any discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? It passes 4-0, and the zoning administrator's ruling is upheld. We're going to take a break.
Mr. Chairman, we'll take a brief break and then reconvene with case number 2016-064. Located in Council District, at the edge of Council District 17, the appellant and owner of the property, Carlson Gray. Mr. Gray, if you want to come forward. Involving the property at 14C Garden Street. The zoning map that I've shown you here highlights Unit A, but Unit C is the one in question here. It's R6 zoning district. This is another short-term rental property case. The permit was denied when applied for based upon prior operation without the legally required permit. The aerial view shows you where this is located vis-a-vis the other houses and structures in the immediate neighborhood. The appellant will have, let me check, actually, is there any opposition present on this case, case number 64? Okay, seeing none, Mr. Gray, you'll have 10 minutes to make your presentation with regard to the item A appeal. There will be no rebuttal time, so empty your gun as you see fit here with these 10 minutes. Mr. Gray.
Hello, my name is Carlson Gray. I live at 14C Garden Street. In December, my family was under considerable economic and personal stresses, and like manna from heaven, the idea of Airbnb trickled in, and we seized the opportunity, not knowing, as I've heard so much about today, that there was a city ordinance that I needed to comply with. And as soon as I was made aware, I tried to comply. So it is, I am filled with anxiety having heard the previous cases and the council member speaking earlier. But I am trying to comply.
So let me ask this. When you first came about, you did not hear about the law.
Correct.
How did you hear about the law?
So the person living at 14B was asking, how's Airbnb going for you? And all this, and then I guess by the time that he had begun to consider, Airbnb had posted a page that let people know, hey, and if you live in Nashville, then you need to do this first. And when I went to do it, they had not done that yet.
Okay. So what he was referring to, and this is something that we ran across, and at least Airbnb is now helping us. It's not help for this particular applicant. That, let's say if I live in Nashville and I've got a friend in Chicago and they tell me about this great website, Airbnb, and I could rent out my home, and I think that, well, that really sounds interesting. So I go and put pictures on my home and put it on the website, and I don't know about the law, and then I hear from someone in code saying that I don't have a permit and all this stuff. So right now, what that used to happen. So apparently now, if you go to register your house on Airbnb and you enter in, you live in Nashville, Tennessee, some sort of window pops up and says there are laws relating to Airbnb and permits. go see these people before you, post your site on Airbnb. So you found out through your neighbor, and kind of that's what happened.
And once I found out, then I came here and tried to follow the steps to do things appropriately, and was denied application for a permit. And as soon as I was able to pay the BZA fee, then I did to get on the schedule. It has not been nearly as contentious a listing as the prior one. On the hillside, my Airbnb folks have pitched in with some gardening projects that we've done. I've got kids next door that I care really deeply about, and I don't allow parties or anything like that. It's just been a way for my family to keep making the mortgage payments and pay down some debts. And like I said, I'm trying to comply. I got the tax forms on my desk, ready to go. Yeah.
Okay. Any questions for the applicant? So you live in this neighborhood. You were owner occupied for Airbnb, I
Correct.
guess you were saying?
Yeah, I live so the bottom floor is like a shared space, and then the upstairs is what they rent. I mean, they can use the kitchen, but yeah.
Any other questions? Yeah, this is this is not an item A appeal, it's just an appeal of the zoning staff's denial of the short-term rental based on prior operations. So John Michael, tell us about why it's that.
Yeah, sorry, that
Why
should
is
be
that?
described as an item A appeal. Any denial of an STRP permit
Is
like
an
this
item A appeal.
is an item A appeal, basically challenging the zoning staff's decision.
Okay. So same thing. Any other things to add?
No.
Any questions, board members? Okay, thank you. We're going to close the public hearing. Okay, so another short-term rental case. This would be owner occupied, and as you heard by the testimony, the thing that's, I guess, kind of different about this case, where hopefully these cases won't happen in the future, is because Airbnb is helping us out now. Obviously, they're not the only site that does short-term rentals, but let's say if I just heard about Airbnb and I thought it was great, and I signed up, or I went to the website and wanted to post my property, that something comes up and says, hey, there are laws in Nashville, Tennessee, regulating short-term rentals of 30 days or less, and before you post, you need a permit. Now, his situation happened before Airbnb started to do that. And so now, hopefully, some of these cases, or maybe a lot of these cases that we get, will be taken care of based on someone, and as the applicant said, he found out really from his neighbor. He didn't know that there was a law relating to these short-term rentals. So that's kind of where he is. What do we think?
Very sympathetic. I don't know what ground we have. I'm very sympathetic, but do we have any grounds?
Yeah, I agree with Dick. It's just heartbreaking almost.
Huh?
Heartbreaking almost.
Well, this is, like I said, one of these cases that, someone didn't know, and then Metro finds out, and the punishment is the council has written into statute, which is their right, is if you are found in violation of this short-term rental law, you cannot get a permit for a full year.
And that's what I was mentioning. I almost said this morning. It felt like this morning, but earlier today, that just seems like a very harsh punishment for someone who just simply didn't know the law. And we've had many of these cases, especially when they try to comply.
Yeah, so Councilman Bedney was here earlier today and kind of asked our opinion about all this, and I'll restate it and repeat it. It's, these are the kind of cases that are unfortunately very common, that somebody hears about Airbnb, they didn't hear about the law, they sign up, they rent their house, and then the moment they hear about Airbnb, they try to get a permit, and then they're denied because they previously rented without becoming licensed. And so that's kind of this case in a nutshell, and the many others that we've heard.
Tell you what, I'm starting to wonder now if it may make sense to defer a case like this for a while and see if the council will make some adjustment to give some leeway to
Well, the
this.
problem is with deferring it, if you're the applicant, he's had his permit revoked. So I'm not sure what a deferral does. And the clock starts ticking, I think, once we.
We've got another, go ahead. We've got another problem. The law that's in effect today would govern what happens to this person, this applicant. So even if they change the law, unless they grandfather some things in, it may not help.
Right.
So as a board, what we can do is either uphold the zoning administrator or overturn the zoning administrator, saying that he made an error in revoking this permit. And that's all we could do.
Unfortunately, I didn't hear anything from the applicant that would justify overturning the zoning administrator's decision myself.
Right, and I'm glad that Councilman Schulman is here to hear this discussion, which is kind of like Groundhog's Day for us. We have our hands are tied, and we're limited of what we can do based on the facts of a case where someone basically rents out their place, doesn't know about the law, comes to codes to try to get a permit the minute they find out, and then is denied based on their previous use of rental, even though they're trying to comply with this relatively new metro ordinance.
Just seems like there should be a first offender fee and not a one-year punishment.
Yes, but as
I
it sits
understand.
today, we are not the legislative body, and the legislative body has given us what we have in front of us, and they, of course, can change it at any time or amend it, which they might, as Councilman Bedney kind of implied, that they're looking to tweak this law, but still, it's.
Yeah, I only said that because we have a councilman present who can do something we cannot.
Yes, and of course, those watching on Metro Nashville Network can talk to their council person if they feel strongly one way or the other about this, since this is being debated. In fact, maybe there might not be a consensus to even change it. I've seen council debate a lot of contentious countywide entities, and there might not be the 21 votes or so to even change this. But what we are dealing with today is the statute in place, and the zoning administrator made a ruling based on the evidence that was presented to him, and that's what we're here to decide, if he made an error or not.
Since we have had this discussion, I would move that we uphold the decision by the administrator, because it doesn't appear we have any choice.
I will second that, but I will make another friendly amendment just to say that the zoning administrator did not err in his revoking the permit. As much as we might like to send the council a message, but we have a councilman here today, and I'm sure he hears us loud and clear. So if that's acceptable, I second your motion. Okay.
Yes.
We've had a motion made and properly seconded. Any more discussion? Seeing none, those who are in support of upholding the zoning administrator's ruling to revoke this permit signify by saying aye. Aye. Opposed? It passes 4-0. And once again, we hope that the Metro Council will examine these rules as it applies to people that haven't done this before and that truly did not have any knowledge of the law. And the minute they tried to fix it, they were still tagged with this violation. So, John Michael.
With that case completed, we're on to case number 2016-066 involving property located at 2800 Marlin Avenue in Council District 24. Frank Santos, the appellant and owner of the subject property, is requesting a variance from setback requirements in the RM20, that's residential multifamily 20 district, to construct 4 units on the subject parcel, shown here in an aerial photo. To refer to the board under the variance criteria from 1712-030 subsection B, the variances are for the setbacks on both sides, the side facing Marlin and the side facing Linmar. The appeal has opposition today. As a result, the appellant will have 15 minutes to make his presentation with his, or have his representative do so. Gentlemen, you'll want to remember to save whatever time you wish for rebuttal after the opponents have given their presentation or presentations to the board. The site plan shown here demonstrates the setbacks as requested at that intersection of Linmar and Marlin. The site visit shows through heavy trees the property in its current condition, the appropriate notice sign placed in the yard, view up and down Marlin. And that concludes the staff presentation. Mr. Barry Cleveland, representative for Mr. Santos and this project, is here to present to the board. Mr. Cleveland.
Thank you, ladies and gentlemen. We appreciate your time and we appreciate being here. What we are requesting today is a variance on the side setback and the front setback. The front setback is a contextual setback of 25.4 feet. We 2 units there along Marlin. We are requesting that those units be, the front setback at being 18 feet from the property line. And then on the side setback on Linmar, we are also asking that the setback be established at 13 feet from the existing property line. Currently, the home that is there now, it is roughly about 12.3 feet away from that property line. So we're actually going to be a little further away from the property line than it currently is right now. The reason for the request is through a hardship on the rear of the property. There is a 20-foot setback, a sanitary easement, the sewer easement, and then there's an 8-foot stretch of property that's on the back of that that's unusable. So basically what we're asking for is from the contextual setback, pushing it back forward by about 7 feet, which basically compensates for the 8-foot loss of the property in the rear. And that's basically it. Got anything to add?
Okay, there's opposition here, so have you talked to any neighbors or the council person, or kind of what's your dealings with the folks that will be impacted by this?
Right. Britt here, he has been talking to the council and has talked to at least one property owner. And I'll let him take it over.
My name is Britt DePriest. My address is 7044 Wild Irish Drive in Nashville. I had a meeting with the council person probably 3 weeks ago, and at that time she stated that she would speak to some of the neighbors and then they would get back to me about their thoughts about it. And they did indicate that they were not in favor of the setback variance.
Had you spoken to any of the neighbors before, and do you know why they're opposed outside of the letters that we have here?
I don't. I just spoke with a neighbor, Mrs. Cheek, who's sitting behind me here, and she had several reasons for being opposed to it, which I'm sure she'll be able to get into when it's their turn to present.
We talked about communications earlier about neighbors and council people, and never being a council person, but hearing a lot of council people in front of our board, normally their process works that you call the council person up and you've got this great idea for their district, and they say to you, well, that sounds nice. let me talk to my neighbors, or let's have a meeting. And if you could convince a majority of the neighbors to support this, I'll probably support it. But if you can't, I won't. Now, everyone has their own way of dealing with things, but, some people, that's kind of how they deal with something. If they're representing their districts, and so if you convince the district that this is a good thing, then councilperson usually goes along with what a lot of people in their district say. So, that being said, I know, I also say that in the light that, we have these cases and they turn out one way, and by the time they come to the BZA or even get to the point of negotiation, that maybe it's a little different or doesn't imprint, it's not in the setback as much or things like this. Have you had any conversation about, making it a little bit more, less objectionable to some of these people that have written to us?
At the time that I met with the council person, she asked would my client be willing to install sidewalks around the property, and he indicated that he would be. But aside from that, I've never heard any specific, until a couple of minutes ago when I spoke to Ms. Cheek, I've never heard any specific disagreements with it, other than just we're not in favor of it.
Okay.
I think Ms. Cheek's comments was, for traffic pulling into the shared driveway, it would be shining in her windows. And that can be alleviated by either landscaping or fencing, but a softscape landscaping would be the preferred methodology for that.
I think we'll let Ms. Cheek speak.
Yeah, and we'll let her go into that. But another thing is, this property is zoned RM20, and it is in a transitioning neighborhood as well. So there's already.
What do you mean by transitioning?
Well, there's already quite a few multifamily developments in the area. Like at the end of the Linmar, there is a development there that's a multifamily development. Across the street from Marlin, it's heavier density as well. So anyway,
you will have time for rebuttal after
Sure.
the opposition speaks if you don't have anything else to add. It's 12 minutes and 54 seconds. So are there any other questions by the board members of the applicant?
I did have some questions.
Sure.
In my notes, I wrote the front, you're requesting 18 feet. What's the required setback in the front?
in the front, this contextual setback in the front is at 25.4 feet.
Okay, so
So,
25, and I'm
right.
sorry, I do remember you saying that now.
Right.
And the side requesting 15,
And I'll-
what's required?
Yeah, along Linmar, according to zoning, there is a 30-foot setback on that side as well, with an additional 5 foot of right-of-way.
So your front is Marlin, okay, because that's where the address is.
Yes, right.
But your side is,
Linmar would be
Linmar.
a side, right.
okay.
We have a letter, an email to our zoning staff from Council Lady Kathleen Murphy, and she in part says, I cannot attend the BZA hearing on June 16th regarding 2800 Marlin Avenue. Councilman Schulman, who is here, is going to try to attend in my place. And she says, at the June 16th meeting, you might recognize some of the neighbors from the BZA hearing a few weeks ago regarding another property on Marlin Avenue. Before addressing issues in this case, I want you to know that I've reached out to the planning department and the neighbors to explore, discuss options if a zoning change or overlay is appropriate here. We believe that granting variances like this one sought in the case would change the character of the existing neighborhood. So it's a long email, but that's mainly her stance on this. So we are going to hear from the opposition now, and Councilman Schulman, you get to pinch hit for Council Lady Murphy. And was this in your district when you represented 25, is it?
25, yeah. Thank you, Mr. Chairman, members of the board, Jim Schulman, Metro Councilman at Large. Council Lady Murphy obviously could not be here, and so she sent me as a replacement. It was in my district, and I know the street and I know the area. Mr. Chairman, I think you took everything that I was going to say sort of out of, because you read the letter. I think she had her meetings with the neighbors. They are here. They're not comfortable with it. I think in the letter she says it's not consistent with the neighborhood. It's a really tiny, it's a tiny little area. And that's a lot of, it's a little space to try to put four houses, four distinct houses on that property. She also said it's going to change the character of the neighborhood. I believe that's in her letter as well. The main thing I think that, at least from what I understand from the folks that would like this, they cite 17-40-370, which is the hardship provision. And in the letter, you'll see that Council Lady Murphy did some investigations on her own to try to determine whether it was the topography, whether it was something. I believe there's an easement in the back that they're citing. She couldn't find one. She couldn't find that they would meet a special need or a special hardship provision. They wouldn't meet that provision of the code which would allow that to get that variance. The neighbors are here. I know that they would like to talk about it. And they've had a lot more dealings on this than I have. But again, I can answer as many questions as I can based upon what Council Lady Murphy said. But she would ask the board to deny the request for the variance.
You've obviously talked to her about this particular case, and we appreciate you being here on her behalf, particularly as the person that previously represented this particular neighborhood. Is there any questions of Councilman Schulman as it relates to this particular, as he's carrying the message that Council Lady Murphy is opposing this and did not find any reasons that she thought that would warrant giving this variance? How many people are here in opposition to this case? And I appreciate you all waiting for our 3-hour meeting and hearing about short-term rentals, probably more than you ever thought.
And I would say, Mr. Chairman, that there is a small child in that.
I noticed we have the Sunny West Nursery here.
That's right, and I believe that child may have raised his hand. His name is James,
Yes.
so he may want to talk as well.
Well, James, welcome to the BZA, and we would love to hear from the opposition. You have 15 minutes worth of rebuttal. As you know, a council person's time does not account against your time, so please come and bring James and or leave James wherever you want. And introduce yourself. Tell us your address for the record.
I have a better picture of my house than just I can't see it up there. I don't know where
Okay,
it
yes,
is.
well, present it so we can know exactly what we're talking about. It. And please tell us where your house is in relationship to 2800 Marlin. Much clearer, yes. Okay, please proceed and introduce yourself for the record.
My name is Terry Cheek. I live at 2802 Marlin Avenue, which is next door to 2800. And I'm opposed to the proposed construction of 4, and I understand 3-story units on the 2800 property. Current zoning is already too dense. Allowing a variance here will violate our neighborhood and my property. Only my driveway separates the 2 lots. The proposed variance would bring the units right up to my property line, requiring me to demand a privacy fence between the lots. The proposed construction would be an unwelcome intrusion to a small and quiet neighborhood. And I might add that all my living spaces, bedrooms, living room, den, everything is on that side of my house, on the 2800 side of my house.
So you would be
have no
facing.
privacy.
Yeah, you would be facing. Okay. Is that it?
That's it.
Okay. How long have you lived on Marlin Street?
I've lived there over 50 years.
50 years.
And I've been under construction most of that time,
So you
beginning with I-440.
Oh,
and
yeah.
Condominiums, and on either side of my house, there are condominiums. On the left side and the back, the Linmar condominiums. And across the street are the Woodlawn Court condominiums. So
Well, We are
surrounded by
glad that
condominiums.
you still live in Nashville and you still live in the
And I still
25th
live there,
District.
and I plan to live there until the time comes.
Thank you, which we hope is a long, long time from now. Next, please.
Yes, hi.
This is
I-
my
I'm-
lawyer and my cousin.
I'm Jim Patrick, and I live with Mrs. Cheek. She's my cousin, and just a little bit of background is that she moved here 1951. Her husband was a World War II vet, and the gentleman that just died in this particular house that lived next door to them for 40-something years was a World War II vet. Two people lived on this particular property for 40-something years, and essentially what this very dense thing that they're proposing would do would be to convert this small property into something where there would now be 4 units with the potential of, 10 to 15 people living there, although that might not be realistic, but let's just say 10. Would create a very dense situation that's not in character with the neighborhood. If you see that Google picture of it's traditionally a beautiful little neighborhood that's kind of tucked in. You wouldn't hardly even know that it existed unless you kind of know that it exists. And it would, and there's already been a lot of density that has occurred there, and we feel that this would create a straw that breaks the camel's back, sort of a thing. If the camel's back might already be broken now, we'd have to check with a veterinarian orthopedic to see if the back is broken, but it certainly is very close. And we want to maintain the integrity of the neighborhood because it's a beautiful part of Nashville, and we want it to continue to be a beautiful part of Nashville. And that's essentially what we have. We feel like that they come to the property and they should take it the way they found it, as opposed to wanting to come and converting it into something different.
Yes.
My name is Beth Applin. Oh, speak.
Yes.
My name is Beth Applin. This is my son, James. The two of us live with my husband, Ben, and our daughter, Susanna, at 2514 Sharondale Drive, which is at the corner of Marlin and Sharondale. Perhaps you can see it.
That where it says RS10, is that
Just
your
across the street, that kind of big square there.
Okay.
That's our home. It's a 1930s bungalow.
Okay.
And to give you a sense of how small Marlin is, you can see that our property is basically half of Marlin Avenue on the other side of Mrs. Cheek. Can you see that?
That's a very short street. Yeah.
It is a very short street. You can't get a sense of it from these pictures that you have. And those condos that you see there, that's what my backyard looks onto. They're half of Marlin and I'm the other half. If that makes sense. We moved to the neighborhood in March of this year. So it's been 3.5 months with our 2 kids. And this is the second time that we have had to write to the BZA about a property on Marlin Avenue wanting to be changed from a single-family unit to 4. It's very disconcerting for me because Marlin Avenue is the kind of street we really wanted to raise our children on. Sharondale's very crowded, the 440's nearby, Woodlawn is highly trafficked. It's a very highly trafficked area with the exception of Marlin, which is quiet, shaded by very mature trees, and since I'm home all the time, I know has a lot more pedestrians on it than anything else. It's a great street for dog walking, for baby strolling, for standing in the middle and talking to your neighbors. It's that kind of street. From what I have seen of the plans, what is going to go up on this corner lot is a lot bigger than what's there now. And I know that Nashville is booming and that we need to accommodate the growing population, but I don't think that every small house that's going to be torn down and replaced with something new needs to have extra room. I think that the lot will be, the builder, the applicant is going to build what he's going to build, but he needs to do it within the current zoning code as it is, and these variances that he is requesting are unjustified. That's my opinion, that's my husband's opinion, and the three of us here today, we're just three, and there's many more neighbors who feel the way that we do. I don't know how many letters got written, but we were at a meeting with Councilman Murphy about 2 weeks ago, and there was, 10 of us there then, and there have been other meetings.
So 10 people in opposition, is that what you're saying?
Oh, yes.
Okay.
I mean, I feel I could go on, but, it's not that, we feel this house should be intact as the way it is and nothing should change. I know the builder's going to build, and let him build within the existing codes and no more.
So you wouldn't see any kind of compromise to what he has being acceptable to you?
Maybe 2 instead of 4?
But you just don't like 4?
I don't, from what I can see, I'm not an architect. This is my first meeting. It's a little hard for me to get a sense of the scale from looking at that plan.
Right.
And I think that the variances that are being sought are going to take basically all the yard and come right up next to Mrs. Cheek, who has this beautiful little stone cottage.
Okay. Thank you. And I wanted to, you mentioned letters. We got a letter from Martha Stinson, who's president of the Hillsborough Weston Neighborhood Association, one of our oldest neighborhood associations in Nashville, in opposition. And she says, "We believe that the requested variances from the zoning code are unjustified and lacking any basis for showing hardship. Furthermore, we believe that it would be injurious to the neighboring residences as the requested variances would negatively alter the rhythm and pattern of this small enclave and, in essence, unnecessarily change its character. We believe that the subject site is developable and buildable using plans that would both increase density and comply with the zoning code. Therefore, we respectfully request that you deny this application," and that letter is in our packet too as well. Do you all have anything else to add in your remaining time, if you want? And is there any questions from the board about their testimony today?
I think what that lady said was extremely eloquent.
Well, like I said, that's the Neighborhood Association, which, like I said, is one of the larger and older neighborhood associations, so I wanted to have their letter read on record. So, anything else?
I think not.
And thank you for being here, Mrs. Cheek, in your longtime residency in Nashville and in the 25th District. Even before Metro government, you were outside. You were in the county, I'm sure, back when. So I won't ask you if you voted for metropolitan government or not. Thank you.
And I want to commend James. He said a lot. A few words.
So excited he's asleep.
Yeah. Okay, let's hear from the applicant again, and he could respond to some of the things that were said. So taking one house and making it 4, you heard from the opposition and kind of their issues about this kind of neighborhood street and the feel and the character, and so what's your response to all that?
If you could bring back up the parcel view of this, would that be possible?
Is that one?
Yeah, yes, sir.
Okay.
If we talk about the character of this neighborhood, I would have to say that the character of this neighborhood, from what I can see in this slide, is at least as much multifamily as it is single family. I mean, you can see from the amount of parcels on each of these properties. I didn't do a count, but I would say it's at least as much multifamily. As far as changing the rhythm and the pattern of the neighborhood, as for our side setback on Linmar, we are actually, a few inches, but we are further back than what currently exists on the property today. So I would question some of the comments about changing the character or the pattern of the neighborhood. I'm sorry.
Oh, so talk about hardship, because, you know, you're asking for a variance, so what's your hardship here?
The hardship that we're referring to is the sewer line that runs through the back of the property. I believe it runs through our property, and then I believe it also runs through Mrs. Cheek's property. There is a 20-foot easement on that sewer line. The 20-foot easement basically starts 8 feet into the rear of this property, which basically would make our, just to simplify the term, it would make our rear setback 28 feet. That is the space that we are asking for on the front.
Okay, so when did you buy this property?
First of all, I should just say I'm not the owner. I'm his real estate agent, basically.
Okay, so when did your owner buy the property?
I believe he bought it a couple of months ago.
So you were the agent. They
I was.
obviously knew about the sewer easement.
He did.
Things like that.
He did.
So, and they also knew about what you could build and not, and I'm sure you talked about the Board of Zoning Appeals, or somebody talked about the Board of Zoning Appeals because they're here. So, sewer easement, anything else being a hardship?
That is the hardship that would signify that would lead us to request the front setback. As to the side setback, we believe that the hardship would be that the requested setback on Linmar is far in excess of what is built there currently.
But that's not a hardship.
Okay.
Right? I mean, you understand what a hardship is, and it's usually related to the physical part of the property, and, you know, you've pointed out the sewer easement, which is physically on the property, but just that everybody else has something else that's not the same.
Okay.
So 4 units, so why did your client choose to build 4 units as opposed to 1 or 2?
The current zoning of the property allows, well, the zoning itself allows for a density of 20 units per acre, which that going into this gives us the calculation of 4 units. It was his hope to build a smaller, instead of building 2 larger homes, to build 4 smaller homes.
Anything else to add on the rebuttal side of what the opposition said?
Sure. The size of the home really dictates the cost of the home as well. So I think the intent of the owner is to make these more costly for families that can afford these size homes.
So, I mean, these are 800 square feet. That's tiny.
The footprint is 800 square feet.
Right.
So what does that mean, the footprint versus what?
Well, the footprint, the first floor would be a 2-car garage and some small amount of finished space.
So what's the total square foot of?
We haven't designed the units yet, but just doing a quick estimation, probably 2,000 square feet.
How do you get 2,000 square feet if the foot is 3 stories?
Yes, sir.
Right.
Okay. And how wide is this shared driveway?
It's 24 feet.
Okay.
And you don't feel like that's overbuilding the property?
No, sir.
That was a stupid question by me, wasn't it?
Well, it meets the zoning for what's there. So, I mean, it meets the zoning. So.
Any other questions from the board? Do you have anything else to add?
No.
Okay. We will close the public hearing. Okay, so we have heard from the applicant in this 4-unit proposal. You heard about the size and the location. So 2 setbacks, one being, I guess it's the front setback, and then the side setback too that they're asking for. John Michael, what is the setback they're asking for versus what is required by law?
I think Marlon, with the contextual setback measurement, which, as you know, is a labyrinthine calculation involving the adjacent properties that are developed, 25.4 or 25 feet 4 inches, I think, was the measurement from Marlon. And forgive me, I don't have it right in front of me. I believe it's 30 on the Linmar side. Corner lots are a little bit unique here. And the reference made to 5 extra feet is actually in part because of, and Mr. Chairman, I'll give you as much or little as you want on this. Ultimate right-of-way is a term that's used by Public Works to describe the width of the street in question here at Linmar, and the minimum ultimate right-of-way measurement is typically 50. So when we measure the 30 feet, it's not just measured from the pavement out in front of the subject property, but instead from the right-of-way, the ultimate right-of-way line. In this case, that's about 5 feet into the interior or grass of the property at 2800 Marlin, on the Linmar side at least. So that's why functionally it may seem like a 35-foot setback. The requirement is 30, but from that measuring point. Sorry for the over-answer.
Oh, nope. We always like lots of information. So board, any suggestions or thoughts on this particular case and what they're trying to do, and what's your thoughts of it?
I don't see the sewer line as a hardship, so I wouldn't support the variance.
I concur with that.
What'd you say?
I concur with that.
So do I, very much so,
You concur with what?
with what Christina just said. that
Okay.
she doesn't
What about the
agree.
side setbacks? And so you don't see the hardship in this case?
No, I don't, and I've read many of these, what have we got, a dozen or 14 letters opposing this?
Yeah.
And those letters have specifics about what a hardship it would be on that community. And that, as far as I can tell, and I didn't hear these words spoken, but as far as I can tell, the only real hardship that the owner is putting forth is not being able to build more units and therefore making more money. And this
Well-
is not about just making money.
And, you know, Council Lady Murphy could not be here. We have her letter of opposition, and we have people here in opposition of all ages, actually. Some people have been here in Nashville 50-plus years on the street, and others just recently. And we have basically the councilperson in opposition, the former councilperson acting on her behalf here at this meeting, and then many immediate neighbors. So those are the people that are immensely impacted by this. So I hear what you all say. So does anyone want to make a motion?
I move that we deny it based on the lack of the hardship.
I'll second.
Okay, motion's been made to deny based on lack of a hardship. It's been properly seconded. Any discussion further, board members? Seeing none, all those in favor signify by saying aye. Aye. Opposed? It passes 4-0. I mean, the amendment to deny, the motion passes. The amendment, the motion passes to deny the hardship. I mean, to deny the variance. Sorry about that.
It's been a long day.
It's been a long day, yes, and still more to come.
Case number 2016-067 is the next one that the board will hear today. Susan Peterson's the appellant and owner of the property at 1164 Fitzpatrick Road out in Council District 13, not terribly far from the airport. This is an item A appeal of the zoning staff's denial of a short-term rental permit due to prior operation without the legally required permit. Aerial view shows you the neighborhood in play here. Ms. Peterson will have the opportunity. Is there any opposition present on this particular case? Seeing none. Ms. Peterson, you'll have 10 minutes to make your desired presentation. There's nobody speaking after you, so go ahead and tell them what they need to hear.
First of all, thank you for hearing my case. I am new to Airbnb. I had stayed at Airbnb.
Identify yourself, please.
Okay, Susan Peterson, 1164 Fitzpatrick Road, Nashville. I live over by the airport. It's called Villages of Larchwood. There is a homeowners association there. I'm on the board. We're scheduled to meet about Airbnb, but I've got a copy of the bylaws. There's nothing in the bylaws that talk about short-term rentals. Back in April, I decided to try something different. I've always loved hosting. My dream is to open up a bed and breakfast when I retire. I'm planning on retiring in 2 years. I thought this might be a good stepping stone to that. I got really sick the last part of March and through April. When I was still sick, when I came to codes, It wasn't until I started reading at the latter part of April that I found out that I had to have a permit. I was sick at that time, and I had missed work. I worked for the state, been there 21 years. I found out about it after I had accepted reservations. I tried to come in, but I was sick in bed. I've got emphysema and COPD. I feel like I'm unprepared because I don't have the doctor's statements and all that with me, but I was sick. My friend Rusty can attest to that. There was one point I went to Care Spot. I had been going to doctors for about a month and a half. My primary care physician told me that there was nothing else that they could do for me, and she referred me to a pulmonologist. I called Vanderbilt and found a pulmonologist, but I could not get an appointment till July. It's mid-July is when I have the appointment. I'm better now. I'm much, much better. But I still take medicine and do my inhalers and all that.
Why couldn't you get your permit, and how did you find out
Okay,
about the law?
I hosted without a permit for 7 days. That was it, 7 days without a permit.
When did you find out about the law?
I found out about the law the last part of April.
And so what did you do when you found out about the law?
I came in here May 9th.
And then what?
I was denied
Based on?
that I had rented for 7 days without a permit
And how did they know that?
because he pulled it up.
Okay.
He pulled it up. I told him. He asked me if it was listed, and I told him yes, it was. And I gave him the name of it, which is Music City Spectacular.
Yeah, we see that in our packet.
Okay. So he said, well, it looks like you have 2 reviews here. And I told him, I said, I'm sorry. I didn't find out about it until late April. It was about the time that I rented. My first rental was April 23rd and 24th. My last rental was May 6th through 8th. I didn't know anything about Airbnb. I did not know what to do. I'm very, very sorry. I'll never make that mistake again. I'm very, truly sorry. Since then,
I have a question. I noticed that your application has you living at, wait a minute. I guess I want to know, is this owner occupied
well,
rental?
I'm in transition. I've lived at 1164 Fitzpatrick Road since May of 2012. What my plan was to move to 2913, and I'm in the process of moving now. I just don't know what to do at this point. But I've got half my stuff at 2913, my fiance, Rusty Whitman. Half my stuff is there. Half my stuff is at 1164 Fitzpatrick. While I rented it out, those 7 days, I went and stayed at Rusty's house. So my plan was to move into 2913 High Rigger Drive. But now I'm not sure what to do. This does put a financial hardship on me because I have an elderly mother that's 82 years old. She's in the last stages of dementia. She's starting to forget family members. It's very difficult. I cared for her for a year and a half. Very difficult to work a full-time job.
You didn't really answer my question. Are you wanting a permit for Fitzgerald or High Rigger?
No, for Fitzpatrick.
I mean Fitzpatrick or High Rigger.
Fitzpatrick. That's the one. That is a nice house. It's 2,500 square feet. Since I thought that I was going to be okay, I went ahead and did a lot of improvements that I'm still paying on and will be paying on. I pulled up my carpet. I put down hardwood floors. They're beautiful. I've got a fireplace, and the hardwood floors match the fireplace. It's a really pretty house. It's got a loft. I can sleep 6 people. I strive to be a very, very good host. I furnish coffee and creamer and sugar and lemonade and bottled water, and I have Susan's favorites places. I mean, I've lived in Nashville for 55 years. This is my home. I have great vision. I have really good vision. I've had great ideas in the past, and every time I've acted on them, usually it was out of fear that I did not act on what I thought would be a good financial move, something that I was passionate about. This is something that I'm passionate about. That's why I want to ultimately open up a bed and breakfast. I thought about moving to New England on the coast somewhere and furnish a bed and breakfast with antiques and hire people to run it. I have failed at other things I have tried. This, I am hoping that I will not fail at this. And I am asking, okay, when I know a lot is up in the air about short-term rentals. I know it is, and I see it from the system. I see it from what's happening, and I don't know what to do. It's like that there is government, metro government is not set to deal with short-term rentals. I don't know who passed that, who the legislatures were that put in there that there is no leniency. And I heard somebody say may. That may is very important. And what I think is important is when Codes denied my permit, he said, you can have a hearing. You can pay $100 and have a hearing. Well, I'm a little confused right now. Exactly what was my $100 for? That's what I'm confused about. And I'm so passionate about this that I will pursue this. I'm not finished with it. You know, if I'm not granted leniency, then I will take it all the way up, because this isn't right. If I can be shut down for a year, being sick, rented 7 days and be shut down for a year, that's not right. That is not right. And I will fight to the end on this. That is not right. When I gave that $100 to Codes, what was it for? What was it for? Ask yourselves that. If that wasn't for who has the power, then what was it for? You guys have the power.
Yeah, to have a case in front of the BZA and appeal a short-term rental, it is John Michael, walk us through the process and
$100 is the minimum fee for any case to come to the Board of Zoning Appeals. That fee covers the man-hours spent preparing all of the documents that are presented to this board, the correspondence related thereto, the legal research pertaining to the case before staff has to present the case to the board, the preparation of the slideshow presentation, the visit to the sites where necessary, the review of the Airbnb listings, among other things. It is the bare minimum we are allowed to charge by Metro Code in order to bring a case to the Board of Zoning Appeals. It's in every instance on short-term rental property cases, we only charge the minimum so as not to make it an undue burden for anyone to get their case in front of the board.
So everyone on our agenda today at least paid $100 to have their case heard by the Board of Zoning Appeals.
And some much, much more.
Oh, can I interrupt?
Of course you can.
Okay. I figured it up, what it cost me. It's cost me more than this, but I have been punished enough. I figured it up. It has cost me $3,107. That's what it cost me because you're welcome to look. Let me present it.
We're really not here to see how much money you put in your house.
I want to show you something. This is what I want to show you. Can I?
Sure.
Who do I give it to?
You can give it to me.
Plus Airbnb charges $50 for each cancellation. So I've got the losses here. I've got the losses.
So you started this by saying that you were sick, and so did that have an effect on?
That had an effect.
What
That's
effect
what I
did
do.
you being sick have on not getting a permit? Or
I was so sick, I had house guests that transferred here that was staying with me until they closed on their house. I'd be glad to bring them in, but they know how sick I was. Rusty knows how sick I was.
what did that have to do with not having a permit? Or
I wasn't able to go to codes. I wasn't even able to work.
But I think
I was ignorant and sick, and I apologize. I apologize. I hold everything in my being wants to do this. I have financial reasons that I need to do this. My elderly mother, she's been the victim of elder abuse, which I stood on those steps of Citizens Plaza at 4th and Dedrick yesterday with my purple about world elder abuse. I stood on the front row of that picture because that is something I'm passionate about. My mother was the victim of a theft of $40,000 plus her vehicle, and now she's also been the victim of about $100,000. And I am paying for her caregiving. And I need the money. I'm an administrative assistant working for the state. Even though I work for the state, have been at the state 21 years, have been an administrative, have been a systems administrator. That too I failed at. I was a network engineer. I was a network engineer.
Let me say to you that I'm as passionate about what you're after as you are. Our hands are tied.
They should know. That's where the issue is. That's where the issue is. And I will not stop. I will fight it because I paid $100 for a possibility.
No doubt.
For a possibility, and y'all are saying that there is no possibility. Well, something needs to happen, and I know that your hands may be tied, but something needs to happen because this isn't right. This is not right.
We agree with you. I agree with you. Absolutely, I agree with you.
What can be done?
We're on this board as volunteers. We get nothing except the satisfaction of helping people.
Okay.
And we do
so,
that when we can.
Okay, what,
We're obliged to follow the law.
right, okay. Let me ask a question. I hate to interrupt you, but I need to follow through when I have the thought in my head. The law is the law as far as variances, but you have the power to override that. The law is the law, but you do have power. The thing is, short-term rental people do not have any power. Who is looking out after us? Who is looking out after us? Who? If not y'all, who?
Well, the Metro Council passed the short-term rental law, and they put in, as far as an appellate process, this board. So
This board does have the power then. You guys just are not recognizing that you have that power.
what the law says is if you rent a property without a permit, that the punishment is a year. So we either have
But you have the power, to be a little more lenient. You're lenient with zoning. Zoning, you guys are set up for zoning, but you're not set up for short-term rentals. Who is set up for short-term rentals?
Well, the codes department oversees short-term rentals, and John
Yeah,
Michael
but they refer, okay, they deny it. and
Ma'am,
refer-
respectfully, I would ask you to not interrupt the chairman of the Board of Zoning Appeals. Make your presentation on your case
I'm sorry.
all day
I'm
if you
very
want,
sorry.
but I don't want it to become contentious. It would be inappropriate.
Okay,
No,
thank you.
but what I'm saying is, staff is slammed with short-term rentals. This is a popular city, and there are a lot of people trying to do this. And right now, as you heard at the beginning of this meeting, there was a council person that was trying to ask us, how do we make this law better? And then we told the last council person basically the same thing, that this is punitive for people like yourself who did not know, and immediately, or when you're physically able to, you come down here and you try to get a permit. And as the law is written right now, it basically does not make any distinction of whether you knew or you were just flagrantly disobeying the law. You're treated the same way, which is, I know, you didn't know. So is there anything? No. Is there anything in your health? You start off by talking about your health. What in your health kept you from knowing or getting this permit?
I found out about the time that the first people rented. I was sick. I could not come to codes. I was sick.
Okay. But before that, you had rented, I guess, for, like you said, 7 days or whatever.
No, sir. No, sir.
So when did you, so I'm confused. So you were sick first and then you rented?
Yes, I was sick for over 2 months.
Okay.
I was sick for over 2 months.
And then-
I worked sick.
And then why did you rent it? What did your sickness have to do with renting it or not renting it or not getting a permit?
Because I started getting requests in before I thought I would. It all happened so fast. I was sick. I wasn't able to deal with it. I started getting requests, and it just snowballed. The whole thing snowballed. I was sick, and it snowballed on me.
You have 48 seconds left in your time allotted, your 10 minutes.
I am sorry. I will never. I'm sorry for interrupting.
Oh, no, that's fine.
My nerves are shot.
Regarding what you can do,
Yes.
I would speak to your council person about this.
Okay.
They're the ones that can change the law. We've
Okay.
been suggesting, and hopefully they're listening, of ways to change the law. We're not legislators. We can only follow what's in the law, and it's a very gray area. And I really encourage you to talk to your council person, talk to many council people.
But council people would be against this, right?
Not necessarily. Not necessarily. There's how many council people? At least over 30, right?
I don't know of
41.
anybody. I'm sorry.
You have 40 council members, and yours happens to be Holly Huzo. Contact her, HOLLY.HUEZO@nashville.gov.
Okay, I
And you
will.
should let her know how you feel about
Okay,
this.
thank
She does have a vote. We don't on
Okay.
changing that law.
Okay.
All of the at-large council members would certainly pay attention to someone who lives in a particular district. So I would contact my own council member and then all the 5 at-large ones.
Okay. There is something I need to ask. I had to cancel reservations that had already been made after codes denied my permit. I had to cancel all those reservations. I was faced with humiliation in front of the guests, in front of my friends and family. I guess I will now be faced with more humiliation to cancel ones in the future. So I guess that's what I'll do.
Thank you. We are going to close the public hearing and deliberate. So these are the norm now, unfortunately, these cases where people don't know about the law and sign up for Airbnb and then find out later. And then come here to get a permit. Basically, they look it up or they ask the applicant and they say that you've rented before. It doesn't matter if you've rented one time or 100 times. If you rent once, you're in violation of the law, the way it's written. So, what do you all think about this case?
Unfortunately, no different than the one we heard earlier.
So, we are here to decide whether the zoning administrator erred in revoking these permits. Any discussion?
Unfortunately, I don't find that the administrator erred. I've got a question. Can I
Yes.
open the public? I want to ask you.
We're going to open the public hearing and you direct the question to the applicant.
Is this the house that you live in now? Is the one that you were trying to get the permit for?
Yes. When I had already started moving stuff in to Rusty's house.
Let me
which is
ask you, where were you going to move to?
2913 High Rigger Drive. That I was moving when that was the plan all along. So I'd already started switching my address to 2913 High Rigger Drive, 37217. I was in the process of moving when codes denied me. So after codes denied me, then I decided to stay where I was at for now. It's closer to my work. It's got a fenced backyard for my dog.
Okay, let me ask our legal
Yes, sir.
person a question over there.
Yes, sir.
When a permit is revoked, is that on the person or the residence?
Yes, is the trick answer to that question. The application is for the applicant the owner at that address specifically. If, for example, Ms. Peterson sold that house tomorrow to you, Mr. King, you could come in and apply and potentially, if you met all the criteria, get a permit. If Ms. Peterson bought another house tomorrow at 123 Main Street and she saw an application for a short-term rental permit at that property, if she met all the criteria, she would be able to obtain a permit at that location.
So if she went to the house where she planned to move and converted that to Airbnb or applied for an Airbnb, that would be legal?
If they meet all the criteria, and I cannot overemphasize that caveat,
Right.
if they meet all the
There's
criteria,
insurance
owner-occupied,
and-
availability, insurance, et cetera, then, yeah, it's a possibility.
I was just
And
thinking
so
out
if she
loud.
sold it to someone else, this current house, and that someone else came and applied for that same address, if they met all the criteria, boilerplate, they would not be prohibited because of what happened to her.
So you're saying it doesn't follow the person or the
It
house?
follows the person at that address.
Only
but not
the
the
person,
person.
only at that address?
Yes.
Oh, okay.
It doesn't follow the address individually. It doesn't follow the person individually.
I wanna make
It follows
sure.
the person at that address.
Wanna
So if
make
she
sure
bought the
I
house
understood.
across the street, she could apply for an Airbnb permit, and if she met all the other criteria, get it issued.
So we're only thinking out loud, trying to give you some
Thank
ideas.
you.
You see what we're saying? Now we can close the public hearing, I guess.
I've got one further question.
Okay, yes.
Rusty currently lives with me at 1164 Fitzpatrick Road. His house at 2913 High Ricker Drive is not ready. It needs a lot of work. It's not ready to rent out as an Airbnb. My house is in top-notch shape.
I would say that just think about where your driver's license are currently.
Okay, all right. Let me ask you this. Okay. There's a question I have. Okay, maybe I need to.
Well, so we're going to close the public hearing again, but what I will say is the way our Airbnb works is the owner of the property can apply for a permit, the owner. So whoever owns this piece of property, or if you buy a piece of property across the street, you could apply. And it doesn't affect, as Ms. Sanford said, it affects the owner at this location. If you are in violation of the codes, then you have to sit out a year. But according to codes, if that same owner that's been held in violation and has to sit out a year of one particular address can buy another piece of property somewhere else, and all things else being equal, they comply with the other multiple things of the Airbnb law, they are eligible for at least to get a permit immediately.
That's not just according to codes. Much, much more importantly, that's according to the ordinance.
Yes. Okay.
Thank you very much.
So let's discuss more. I'm glad that we brought that up, and maybe, there's kind of loopholes in all of this. Is I think yeah, we closed the public hearing, so. Okay, discussion.
Unfortunately, I guess I must move that I don't find that the administrator erred in his decision, so.
Okay, motion's been made to say the zoning administrator did not err in their.
So that would be to deny the appeal, yes.
Yeah, deny the appeal of the issuing the permit. Is there a second?
I would second.
Okay, motion's been made and seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes for upholding the zoning administrator's ruling 4-0. So.
Mr. Chairman, that brings us to our final case of the day.
We want like a 3-minute break.
The board takes a small break. We'll reconvene on case number 068.
So basically.
Holdings, LLC, on behalf of Mary Ann Scales, owner of the property located at 1036 24th Avenue North, there near the intersection of 24th and Meharry in the 21st Councilmanic District. The case is brought on an appeal of denial of a building permit for a lot with less than 3,750 square feet, which pursuant to the zoning code is the minimum square footage for any lot that can be developed for residential, single-family, or two-family use. This is in the RS5 zoning district. The appellant also requests a variance from rear setback requirements in the RS5 district in order to construct a new single-family residence. Board members, I would note that you should take into consideration the portion of the appeal having to do with lot size, as if the board does not find on behalf of the appellant with regard to the lot size appeal, the setback requirement portion of the case is mooted. So with that, representatives for MLM Investment should come forward, or representatives for Ms. Scales should come forward to present their case at this time. Is there anyone here in opposition to the case? Seeing none, the party will have 10 minutes to present their case among all of them who wish to speak. Okay, raise your hand.
Are you in
Do it when I ask
this
for it.
opposition?
Apparently there are folks here in opposition. The
So you will have
proponents will have 15 minutes. Do remember to save some of your time for rebuttal. The opponents will have the opportunity to speak in opposition after the initial presentation by the appellants.
Okay. Welcome to BZA. Introduce yourself and your address for the record.
Can you hear me?
Press the button and the red light will come on. There.
Thank
Okay.
you. Okay, Diane Mayo. I'm representing MLM Investments. My address is 1016 Derby Trace, Nashville, Tennessee, 37211. And also, for full disclosure, I'm a realtor with a local real estate company. And Mr. Jeremy Enders listed the lot for sale that you see there, and I immediately put a purchase offer contract on that. And we have it under contract now. I also am partner in the MLM investment, so that's how that works. Okay. Upon placing the purchase offer on the contract, I became aware of the fact that there's an ordinance, which you're aware of, that makes the lot unbuildable. The minimum requirement is 3,750 square feet to build a single-family home. So I did go to codes and discussed at length with them the requirement, and they suggested that it would be okay to do the BZA hearing and request that to be looked at. So that's why we're here. Also, so that's the first part. That's the type A. And unless we get past that, then we don't have the variance request. So this lot is I don't think you have a picture of it up there.
Can you have the real picture of it? There.
Yes, okay. You can see it's really flat, and it's in a neighborhood, and it's very conducive, of course, to building a nice historical representation, actually, is what I've got in my file of a home that we would build there. So it seems to be a perfectly buildable lot, and I didn't know if Jeremy knew that it wasn't buildable when he listed it or not, but we subsequently found that out.
Who did you buy it from?
Okay, and I haven't purchased it yet because we're doing our homework, and he represents the seller.
Mm-hmm. Who's the seller?
The seller is David Scales.
Do they live in the neighborhood, or how's this work?
No, and I don't have David's address. He's in Davidson County, Nashville.
And what's the listing price, or what's the price that you'll purchase this for?
The listing price is $25,000.
$25,000, okay. And how big's the lot? 337?
It's 54 by 60 according to the tax record. So it's around 300 square feet short of the ordinance 3,750.
It's 265 square feet short of the 3,750.
Okay.
And I think I read this, but is it correct that the parcel was created in the 1930s?
Correct. It was created in 1935, actually. Okay. And a note also that the ordinance requiring the 3,750 was passed May 24th, 2013. So the lot had been there since 1935. And there were obviously no zoning restrictions at the time that was created. And it sat there for all these years until your client decided to sell it. So there were no 3,750 square foot ordinances back when the lot was created. So it seems that there should be, it seems to me that there should be.
Oh, and you have proof that it was created in 1935?
I do have the deed, yes. Do you have that or not?
Members of the board, I think it's the third or fourth page in your packet. That
Okay.
which looks like a deed from 1935 is the document in question.
Well, that is the documentation that I have.
Is that for the separate property, or was this subdivided at one time, John Michael?
Based upon review of everything from prior aerials to the sandboard maps of the 50s, and we even had planning look at a 1930 U.S. Geological Service survey to confirm that, number one, this property has not existed in its exact condition all the way back to 1930, but that it has in fact kind of been part of the property shown here to, I guess that's actually the south. If I may gesture with my cursor on the picture here, at one time it was part of the property just down here a little more. I thought upon first review it was bound to have been part of the one to the immediate north, but that turned out not to be the case. So after we checked with planning on that, that's to some extent neither here nor there. We're not in front of the BZA right now if there had ever been a house constructed on this property. despite its deficient lot size, which is plain letter in the zoning code, we don't have authority to do anything different at the staff level. If there, in fact, had been a house built out here at some point, then it would have been a matter of a legally non-conforming use. And we see that from time to time on lots that otherwise would be rejected for building permits because of insufficient lot size. However, because this patch of grass, 54 by 60, what staff has identified as 3,240 square feet, just shy, a little over 500 feet short of what's required. Because it's never been developed with a house or anything else that we can find dating back to records in 1930, we don't have a leg to stand on in terms of finding permission for the building permit. They don't meet lot size, and that gets it denied 10 times out of 10 at the staff level. And, of course, they have the right to come to the board and solicit a different opinion.
Okay, thank you. So, you're not, do you have any proof that there was ever a house on this lot?
No, I do not.
Okay, but so are you saying that this lot, the way it's configured right now, when was this configured in this particular?
The best I can tell, it was the 1935 configuration of, let's see. He would, yeah, right here is recorded November the 18th, actually, I think that's 30, it's 35 or may even be 33.
It is 33.
It is 33, yeah.
Yeah, I can see it on my copy. It's
Okay.
33.
Okay, so you're saying you believe it was this size lot back in 1933,
Well, since 1933.
but you're also saying, we're looking at the dimensions of the lot in this deed from 1933. And it says westerly 60 feet and northerly 119 feet. So obviously it changed at some time. Do you know when it changed?
No, I do not.
Do you have any other testimony for us? You will have the time for rebuttal that you don't take right now.
Okay. Do I need to prove a hardship for this type of appeal on the portion?
This is an item A appeal.
Right.
And it's basically, John Michael, help us with this, that the minimal lot size for building in Nashville, why do we have that law, and how does this affect this particular parcel?
To the first implied question with regard to item A appeals, did the zoning staff get it wrong? Did the zoning administrator err or act arbitrarily in his decision is the criteria here for item A cases. Why do we have minimum lot size? It's a public policy call. That's not a determination made by the codes department. It's not an internal policy. It is law. The zoning code at 1740-670 subsection A regarding single-family structures in residential districts such as this one, which is RS5. The exact language creates multiple criteria. If you've got a legally created lot, if the lot contains a minimum of that 3,750 in square feet and existed prior to the effective date of the ordinance codified in this title, which I believe takes us back to at least 98, probably 96, then you're fine. So there's no question about whether or not this is a legally created lot. There's no question about whether or not the zoning ordinance came in after the creation of the lot. The last criteria that has to be met is a lot size of 3,750.
And what's the lot size right now today?
I believe staff had recorded it in the original application when they reviewed as 3,240. 3,240.
So basically 500 feet, square feet less than what we allow.
Is that what you're surveying?
I think that's
Okay.
about right.
And that's based on the 54 by 60 dimensions that were provided to us.
Okay. So,
I guess you should say, if they don't make an exception here, then the seller has a totally worthless piece of ground, basically, and that Metro's actually going to hold it for no.
well, it's not. I mean, I guess you can sell it to the person of the contiguous property, and they can build or have a nice fenced-in backyard, or
That would be up to the agent then.
The current seller, the owner of the property, purchased this in 1991.
For how much?
From Metro.
From Metro?
From Metro.
For how much? Why did Metro own this?
It was a tax sale
Okay.
at the time.
And so how much did they purchase it for?
It was a lot less than it's worth today, obviously.
Well, how much?
I can look it up.
I mean, ballpark.
Hundreds of dollars.
Hundreds of dollars. That's
Yeah,
what they purchased
that's
it
right.
for.
That's right.
Okay. Yeah. Anything else before the opposition speaks?
I guess
Yeah,
before the
something.
opposition. Pardon?
No, I just think it's a great flat lot for a very, very nice single-family home, which, as you all know, is something that Nashville is short of right now. So that's, yeah, and then we'll let the,
The lot in the neighborhood is very, a great place for this to happen right now. In fact, I think it would spur the neighborhood to, ignite that change from, currently there's a lot of vacant lots, and there are actually vacant homes in that neighborhood. As I have been to many of them, there are homes in there that.
Well, why not buy a vacant lot that's a buildable lot per se? If you
This one is available.
The vacant lots in this neighborhood aren't available?
There aren't right now. This
So
lots
this,
are sought
this
after.
small lot, one of your arguments is if you're able to build on this, this will have a renaissance in this neighborhood if this one lot gets a house built on it?
It always takes the first one, right? Now, there are some renovations taking place in the neighborhood, but as far as new construction, the one next door is several years old now. But anytime builders and developers see new construction going on in an area, it makes it more desirable for them to begin their investments in the area and transitioning from homes that are in their current condition to homes that are in a much better condition, or new homes, creating a much better environment for homeowners.
Okay. Let's hear from the opposition. You'll have,
I think, don't we have to hear the variance part of
we'll
it,
hear
just to-
the item A, the acting instead of the zoning administrator. John Michael, will you?
Oh, no, I'm sorry, the variance part of it, don't we need to hear that now?
You can reserve and treat it as a second item, because in reality, if the board were to, well, yeah, you can.
I think I'd like
You
to
see where
hear
I'm
it.
going. If for
let's
some
hear
reason
your-
you're shot
yeah,
down on
let's
the
hear your
item A,
variance
it's moot.
arguments. We'll let you
Okay,
make those right now
okay. Well, in your packet is,
in your hardship.
okay, in your packet
Mhm.
should be a copy of the single-family dwelling that we had scheduled for the lot. Do you have it? Do you have that, or can you show that?
We have some information on it looks like a house that you are
Yes,
proposing.
yes. I mean, that's the proposed plan for the lot, which is very, it seems historically appropriate for the neighborhood.
What does historically appropriate for the neighborhood mean?
Well, it's of the same character of other homes in the neighborhood. It's not a modern structure as some you've seen in town. I'm sure you've seen
But it's
those.
kind of a two-story structure. And
two-story,
most of the
but-
neighborhood is kind of these bungalowy, Tudor 50s, 60s structures.
And I think there's probably I think there's a variable structure in the neighborhood, but it is a two-story, but
Okay.
it is an historic replica of other homes that would have been built in that era, let's say.
Which era?
In the 30s, when the other homes were built there.
Okay.
So it would fit into the neighborhood as
Okay,
well.
so let's talk about the variances.
Yes, and the only variance would be, okay, so, of course, the building code department could give me the required setbacks if it were a lot, even though they say it's not a lot, right? Okay, so their back variance is 15 feet, and I was asking for a 2-foot variance in order to build the home.
The setback's
setback,
15.
yeah.
You were asking
Yeah.
for a 2-foot setback from the property line.
From the back. I'm sorry, there was a,
Yeah.
Yeah.
If I may
2-foot
assist.
variance to the 15-foot setback.
to the 15-foot rear only.
Okay, rear.
Because we can meet the other setbacks that were given to me by the Metro Codes Department, even though they do have those on record as those being the required variances for this parcel.
Okay.
So it's just 2 feet.
The variance request on the back
And
is
so
just
what's
for 2 feet.
what's your hardship then?
Okay, the hardship on that, of course, without that 2-foot variance, then we couldn't build this particular home, but we could probably look around and find another one, but this is the one I thought was.
What's the hardship based on the land?
The land?
Mhm.
Okay, well, I think we have several there.
Which
You
is?
cannot construct a new home for the neighborhood and the community, which we know is desired very much in the Nashville area, just in general, because of the lack of single-family housing in affordable neighborhoods. That's one. The seller, of course.
Let me speak just a little bit to
Sure,
that.
okay.
The hardship for the seller, provided this sale does not close, if she's not able to obtain the variance she needs to close this contract, the owner will maintain ownership of the property. The hardship there is he's paid taxes on this for several years.
But how much is this worth from the
He's,
city? If he paid a few $100s for it, what do they assess this as? John Michael, what's?
I
Okay.
think the assessment, actually, think I know that, I think of the
Is it about
assessment's
5 or
11,000.
10,000? What?
This is 11,000.
Okay.
Maintenance of the property.
But, to me, that doesn't have to do with the physical characteristics of the property. That's what we're asking a hardship for.
Oh,
Not
okay.
that he has to
All right.
carry the taxes or,
Okay.
he could sell that property or he could do whatever, right? But that's not a hardship for the seller that he doesn't get to sell his land that he's been paying taxes on.
Well, he's not, I'm just saying he's not able to build on it, so he's not able to make use of it. But yeah, he's maintained it, kept it green, kept it clean.
Okay. Well, has he tried to buy some contiguous property to make it a buildable lot?
I have not offered that to him. It's not his
Okay.
goal to purchase more.
Okay. What were you going to say about the hardship? Like I said, we deal with hardships that are physically dealing with the characteristics of the land that keep you from building something or a certain size house on it or a certain location on the lot. So that's why we asked, what's the physical hardship based on the this particular lot that keeps you from building? Is there one?
Only hardship, of course, is the restriction for the 15-foot variance that's on the back, which doesn't affect the front at
But
all.
why can't you build within that 15-foot variance?
Well, perhaps we can shrink this down and do that, but just to take this plan that I had and to go ahead with that, perhaps it could be shrunk down to fit that.
Okay. Anything else to add before we hear from the opposition?
No.
Okay, let's hear from the opposition. Please identify yourself for the record and your address.
Sure. My name is Megan Adkisson. I live at 1034 24th Avenue North. I'm the south property that you guys were referring to earlier. I have no opposition as far as someone coming in and building in our neighborhood. There are so many lots and so many homes that can be rebuilt. I'm fine with that. But I am concerned that this lot is so very tiny. And if you look at all the other lots in our neighborhood, they are nice-sized lots, and all of them line up very well together. In this lot, it is just so small, and I would recommend that it extend to the very back lot going into the back of our neighbor's property, if they could potentially get that. And
So
then they could build whatever they would
Why
want.
are you objecting to them building this house on the lot the way they propose?
It would not fit, I don't think it would fit the character of our neighborhood. I don't mind it being a two-story home, but it being such a small, narrow house, it would not fit the neighborhood at all. Now, if the lot was bigger and they could set it back all the way, and there was a yard and everything
But
was.
that's the issue. I mean, it's a tiny
Right,
lot.
it's a tiny lot. And I don't, like I said, the only thing I can think of is for they to buy the back lot.
Okay.
But that would mean that someone would want to sell the back property. And as far as that property goes, like I know that the Scales family has owned that, and we've tried to contact them to buy it, and that was 8 years ago that we've lived there. And we have mowed that lawn for 8 years. No one has come to maintain that lawn for that long.
Do you keep on mowing it right now?
Oh, yes, keep mowing it right
Why
now.
do you mow land that's not yours?
Because it makes the neighborhood look nice, because otherwise it gets incredibly tall. And it's a great lot. Like, the reason why like, the grass is great is because we mow it, and we cut everything back. But anyways.
So, where do you live?
I live at 2401 Meharry, and I'm in the corner lot at Meharry and 24.
How long have you lived there?
I've lived there 11 years.
Okay. And why are you opposed to?
Because, like she said.
She hasn't given us her
Oh,
name.
yeah, I'm sorry, your name. Your name is-
Maxine Chandler August.
Okay.
Okay.
And why do you oppose this?
Because I look at that lot, and when they moved in, I always thought that lot went all the way back to that far, past that, the back, all the way to 56, yeah, to the fence. And so I would have no problem with that, but in looking at the size of that lot now, it is too small to put a house on there. And if they're looking at building up, because when I'm looking at those figures that they're saying for the house and everything, it's going to almost sit on the street, and then it's going to have to go up. And that's going to take away from the rest of the neighborhood, because all the houses sit back. They all have some type of area in the front of their homes that they can mow and everything, and the kids can play in. And if that sits all the way on the front of the street, then that's blocking her house off, and then also blocking her kids from being able to be seen if they're out in the front yard playing or whatever, and it could be dangerous. And then it opens up in that alley, it comes straight out into that lot.
Okay, you've lived there for 11 years.
Mhm.
They say if this one lot was developed, there would be this kind of renovation and revitalization of the neighborhood. So are you holding that back?
I'm not holding it back. I think we're revitalizing already. They moved in when they built that house there at the end of 24th down at Herman Street. They're redeveloping
A big, beautiful house
a
down there.
nice house on that corner down there. Other people are redoing their homes, doing different things to upgrade their homes.
And you're just a few blocks away from the Cal Turner and Family Center at Meharry?
I work at Meharry, yes.
Okay, so that brand-new building that
That
costs millions
brand-new
of dollars
building's
is
sitting
right
there.
near you?
Right there.
Okay.
I worked on that building.
Oh, you did? It's a beautiful building.
It is. I'll say on
behalf.
behalf of Moody Nolan, thank you for saying that.
No, the Cal Turner family, brand-new building, and the generosity of the Turner family to Meharry was, they really needed that building, and it's
Yes.
really a great addition to the neighborhood.
Sure,
It is.
agreed.
And people are moving in, and
Yeah,
you know,
it's just the lot size, yeah.
not just renting, they're moving in and buying homes over in that area.
I don't, you were worried about the house being too close to the road. On this drawing, we have a
Oh,
survey
we didn't
drawing.
get a copy of the drawing. No one
Yeah.
has ever came to her house or to my house, to my knowledge, to ask us
discuss
about
it. Yeah.
building something on that lot.
Well, it's set back 20 feet from the road. The
Okay.
neighboring
Okay.
house, I believe that's yours.
Okay, sure.
On this survey, or it's maybe not an official survey, but it's done by a surveyor, your house is set back 23 feet, so it'd only be.
Okay, so it's not right
not
up
on
on
the
the,
road.
okay, that's good.
I did have a question for the codes department. With this house, I mean, I guess the setback is determined at 20, but is it subject to those contextual setbacks we've been discussing in prior?
I didn't review the application when it came in. It was done by the chart, though. The contextual setbacks, of course, apply to street, not to rear. And so the plan that was submitted, they just saw that there was a definite need for the rear setback variance
Okay.
from the chart of 20 down to 18. I think it was called 15 and said they were seeking 13. They're right, they're only seeking 2 feet, but the requirement is 20. They're seeking 18 on the rear.
Yeah, no, I understand it doesn't apply to the rear. I was just wondering why 20 was allowed.
And just looking at the lot, like I've, walked over it several times, I think it'd be very hard to put a substantial house there unless it was incredibly skinny and tall. It just is not big enough. There would be no place for parking or anything like that, or you wouldn't even have a backyard at all. So I don't know. I just would love to see that to be a full lot. And I know that's not what we're talking about today, but.
When the applicants come back, maybe they can address the side setbacks
Sure.
that are on the
Sure.
proposed plan.
And could we see the plan? Is that possible? Like the house, since we didn't see that? Thank you so much.
Okay.
That's all we have. Thank you.
Okay, that's it? Okay. We're going to hear from the applicant again. Unless, do you have anything else to add after you've seen this? Ms. Atkinson? Ms. Atkinson, do you have anything else to add? Do you have anything else to add during this period of time? Okay, thank you. We're going to hear from the applicant.
Do you want to say anything first?
Yeah, I can speak to the setbacks.
Yeah, I'm sorry, I think I had that incorrect. The rear setback was 20, and we were asking for 18. But the house is not really skinny, it's really wider than, it's not a skinny house. I know she's probably thinking about houses where they've knocked down one and built two, and they're extremely skinny,
So
narrow.
what are the dimensions of the house? I don't
It's
have my
20, it's 31 across and 22 deep.
So the total square footage is,
It's about 1350. So,
And it would meet all the setbacks except for the one in the rear.
the rear.
The 2
right,
foot.
right.
So just doing quick math, it might be 10 foot from each side property.
Yes, we met, I know we met the guidelines for the side, and they are the
I
side
think you had the
guidelines.
survey up there once that shows
Yes,
them.
it should be in your packet. I know we have to flip through.
anything else to add or any questions from the board?
I know,
It sounded to me like the biggest opposition to building was the concern about it maybe being an urban-style home going on there. You can see it's a traditional-style home. There was concern about it being built
But
on
there's
on the
no
road.
historic overlay in this area. I mean, you could build a modern house, you
Sure,
could build
yeah.
an old house, it doesn't
Right.
matter.
But that's what I was hearing as a concern as part of the opposition. You can see that's not what's being
Right.
asked to build there.
Okay, and we
Uh,
asked earlier, and I'll ask you again, the deed that we have from 1933 appears that that is not this lot exclusively, that there are some of the contiguous lots around it, and it's bigger than this. So what proof did you have that, do you know when this lot was made this small?
no, this is what I received from the the building department when I went to discuss the permit. So he
But if you're
pulled-
looking at the 33
Yes,
deed.
I see what you're saying. He pulled this up.
Right. And
And-
at one time, the lot was a certain size, and obviously, land was sold off to neighboring properties to make it
Right.
this size.
It was long previous to the current ownership. So
Right.
That's all I know. Going back
But
to
that,
90.
why that's relevant is, once again, Metro has this law about the 3750 being the minimal lot size that you can build a house on unless there was a prior house on there.
Do you have the survey that that came through?
And who are you?
My name's David Scales.
Oh, you're the owner. Okay. Now, we did not hear from him previously, but I do want to hear from Mr. Scales. So, yeah. Okay. So, you own this particular lot.
Yes, I do.
And why did you buy this lot?
Investment, just,
Okay.
it was an investment.
And so, when you bought it, you obviously bought it for, how much did you buy it for?
I believe it was $450.
$450.
Yeah.
So, but when you bought it, you probably knew that it wasn't a buildable lot at the time, or what did you think when you bought it?
No, I bought it believing it was a residential lot, and when I bought it, it was owned, that lot and the lot next, right behind it was joined together. They was owned by the same person.
Then what happened?
And so
Did you sell it? Did you subdivide this lot?
No, I didn't subdivide it. Metro subdivided, if anybody did. And what the two lots were up for sale. And so when I got to the sale to buy, to bid on property, the lot that it was joined to, it wasn't for sale at the time, and so I found out Metro.
Oh, so the person paid their taxes or whatever, and it didn't get sold?
There was they both was at a tax lien.
Right, but then when it came down to actually sell the properties, only this one piece got sold?
That's the one I bought, but Metro kept the other one.
Okay.
And so that's what happened, and that's why it actually looks like, the back of it is going to always be green, and it looks like it's, part of the yard. And that's what I thought also. And I did try to purchase 10 feet or from the land rest of the back from Mr. Tunga that lives in that house. But at the time, he didn't, and this was some years ago, he declined to sell.
Mr. Scales, where do you live? I don't think you said for the record.
I live at 4616 Setter Court.
Okay. And so the opposition says that they've been cutting the grass for 8 years. What's going on over there?
Well, they offered to cut it, and
before that, it sounded
I
like
offered to pay them when during the spring and the summer I noticed it was cut, and so I knocked on the door, and I spoke with a gentleman, and he said he cut it, and I said, well, I thank you, and let me pay you. And he said, no, don't worry about it. We'll cut it when we cut our yard because it'll look good when everything's cut at the same time.
So before that, have you ever cut that grass?
Absolutely. I've been weed eating and cutting it all summer and pruning her fence and picking bricks up out of it and bottles that people sling over in there, and also, to speak to another point that was brought up, I believe it was maybe a shotgun house on this property at one time because there was a lot of bricks and the ground was sunken like it was.
When would this have been?
It'd been, maybe back in the 30s or 20s, a long time ago. And I believe those structures were just, fell down or torn down, and
we have a Sanborn map, I think, from the 30s on here, and John
The
Michael.
Sanborn maps are from the 50s. I think they were 59 and 56 respectively.
Okay.
No house. The 1930 U.S. Geological Service survey, no house. I don't have anything before 1930. And Mr. Herbert, of course, the zoning administrator, who is much, much older than I am, may have a better recollection of the development of that property. However, he's not able to be with us at this hour.
Okay. Thank you. So, anything else to add?
I know the opposition was talking about, well, if we could go buy some more property. Well, that's obviously not feasible right now because I don't think they want to sell. But, so you would be asking the neighbor on Meharry, I guess, to give up their backyard. And so, that's not on the table at the moment. So we were working with what we have and trying to work within the codes and the ordinances that are here before us today, and that's why we've made this appeal.
Okay.
So-
Anything else to add?
Don't think so.
No, this whole thing came up at the time that, building permit was applied for. We didn't realize that, prior to that it was a restriction against a 3750 and under square foot lot. It's been an educating process there. And the whole day's been an educating process, actually. That's a good place to get a free education.
John Michael, how long have we had that rule about 3750 roughly? I mean,
At least since the 1998 codification of the modern Metro zoning code. I don't know if it was part of the 1974 Mezzo as well, but I know that
but at
since
least
98.
okay, thank you.
What is, excuse me, may I ask a question? What is the ordinance then that was passed May of 2013?
There were
Is
several
that-
hundred passed that year. I'm sorry, I don't know which one.
It was, I thought that was the 3750.
Sorry, I'm not able to speak to that.
But you did say that earlier. That's what I wrote down. That you
Right.
said there was an ordinance passed May 24, 13 that required the 3750 minimum lot size. Maybe you were thinking about something else.
So fairly, I mean, it could be recently, it could be 20 years, almost. Okay.
And Mr. Chairman, the last bill that was passed with regard to any portion of 1740-670, the subject ordinance in play was passed in 2013, or was at least filed in 2013, presumably passed in 2013 as well. It has been amended a number of times through the years. The question that was originally asked was, when did it come into play?
Right.
I know at least January 1st, 1998, based upon the 1996
Okay, but then
ordinance
they
that
could
gave rise
amend
to
it to
Mezzo.
different things.
It'll get amended 100 times
Sure.
before any of us retire.
Okay. Anything else to add?
No, that's all.
Okay, thank you.
Be a nice addition to the neighborhood, be a nice addition to tax base.
Okay, we're going to close the public hearing. Okay, last case on the agenda. I am very familiar with this neighborhood because right down the block on 24th and Albine was the first house I ever lived in until I was age 2. My father was a physician at Meharry. And when I was in law school, I lived in the basement for 1 year of that same house. So I've looked out on that lot before and know it. This is a interesting neighborhood because it's close to Meharry, Tennessee State, Fisk, and of course downtown. So it is not surprising that someone wants to build a lot. So as John Michael said, we are here to determine there are rules related to the physical size of a lot. And the rules say, as it currently is written, the smallest lot that you could build a house on is 3,750 feet. This house is about 500 feet off of that. So we are here to decide whether the zoning administrator erred in finding that this was denying the building permit based that the lot was not 3,750 feet. So that's why we're here. And if we do find that he erred, then we get to talk about the variances.
I know we're not supposed to look at precedent, but I seem to remember a case last year, I found it in April, that we had the same issue with the lot size. I don't know if either of you remember.
Where was that case located in?
Oh, 2015-024, I think.
But what was the address and what district?
Woodmont? Does that sound familiar? Is this the right one, item A?
Oh, this is the case over on Woodmont Boulevard where they wanted to, I think, subdivide 4 to 6 houses, John Michael.
And that fell to the originally platted lot lines question with state law protections for restoration of originally platted lot lines.
I think the difference in that case was the lot lines were originally plotted out in the 30s when Concrete Boulevard, which was the first paved street in Nashville, or outside Nashville, then became Woodmont, was done, but they never built structures on there. But the original plot lot lines never changed. They were never combined. And so these lot lines, which would be very small by Green Hill standards today, since they were recorded prior to 1935 or whatever, the developer was allowed to potentially build these individual houses on much smaller lot lines than what Woodmont Boulevard, which I think is about a minimum of 2 acres today, or at least an acre, so.
I don't know.
So I
how's-
think that's the different, if that's the case that you were thinking of, the plot lines that were developed and recorded and not changed all those years. And so that's why that was different. So,
Still seems similar to me, but I guess.
well, I
can't
guess
really
then that's why I was asking about the 33D. The 33D shows a bigger lot. And so if the
Yeah.
33D showed the lot that size and it was never changed, then that's a different story. But obviously, this was changed at a later date. So the magic number, as Sunny West used to always say, is 1935. What's the, or I guess here, when we passed the 3750, when was, and that was obviously, yeah, more recent. So at least 1998. So if it wasn't built upon, before 1998, then, or there's a prior structure which, okay, there are bricks on there. Is that proof of a structure? Not necessarily. We don't have, we looked at a 1930 map, we looked at one in the 50s, and that's kind of all we have for that area, which most of the homes, I think, were developed kind of later, mid to late 30s, early 40s in that neighborhood. So, I don't know. So what do we think? So did the zoning administrator err in finding that this lot was not the right size and therefore cannot be built upon? So our architect think?
There's 2 of us.
Yes. Our 2 architects. So what do we think?
I think it should be. I mean, I think it should be built. Something should be built, but I don't know how to get that done. These item A appeals are so difficult. It's so difficult when you state it so simply that did the zoning administrator err or act arbitrarily? No, he really didn't. But it's just so hard to hear these. It seems like if it could have been a variance on the lot size, I don't know, maybe that could be easier to approve. I don't know why it couldn't be filed like that.
There are minimum standards for a reason. That, the
I
council
agree.
passes that.
Yeah.
And it's kind of like these others.
I don't disagree, but this is just a lot that's not usable if no one can build on it. I don't.
Now, Alma, we get the lawyer jokes all the time, but is there an architect joke here, kind of like, a hammer seeing a nail, that, if there's a lot, an architect likes it and wants to build something on it? What do we think? Alma, what do you think of this?
I think that the administrator did not err because, here again, we don't write the code. We just have to abide by the code. And I feel like our hands are pretty well tied. And I'm not, and as Kathleen had said in one of the other cases, financial loss is not a reason for considering a variance. We're not at the variance stage. But
Yeah, that's why I asked the questions about basically how much was this lot bought for originally, and it was like, tax sale, $400 some. And then, the deal, if the new person bought it, it would be for about $25,000, which is probably still slightly under market of what, even in that neighborhood, a lot that size would go for. And so if you go into a situation knowing that you're getting something under market, and there's a reason, maybe, as the applicant, as the owner kind of said, well, what can you, the realtor said, what can you do with this lot if it's not buildable? Well, that's just kind of the risk you take if you buy something at a very low price and then you try to buy the contiguous properties, or you could sell it to one of the contiguous neighbors, but that's kind of where you are right now.
Well, and we heard one of the neighbors say that they had tried to buy that lot, so.
Right.
there is a possibility of sale.
But with the, increase in the hot real estate market, a lot of lots that would have never been considered are now in play, and, areas that people wouldn't have done this even 5 years ago or 2 years ago, due to the housing shortage of homes, and particularly in the city's core, this is desirable neighborhood and people want to build. So, Dick, what do you think?
I agree with you. I just don't think the administrator erred. I mean, he just followed the law,
So do you want to make a motion?
I don't know what to make.
Either he erred or did not err, and,
Well, I move that he did not err.
okay. So.
And I would second.
Okay, motion's been made and properly seconded. Any more discussion?
I just think it's unfortunate, that's all, that there's no way to really build on this lot, but I agree with y'all.
I agree with you, so unless they come back for some other variance on something, like get a variance on the size of the lot. I don't know if that's possible or not, but I stand by my motion.
Okay, motion's been made, properly seconded. Any further discussion? Seeing none, all those in favor of the motion upholding the denial of the building permit that the zoning administrator did not err, signify by saying aye. Aye. Opposed? It passes 4-0. So,
The appeal is thus denied by the board.
Yes.
And that will conclude the board's business for today, June 16, 2016.